बाकी लोग YouTube में भी सुन लेंगे ना, YouTube भी दिया हुआ है लिंक। आनंद टिब्रोवाल सर की सब लोगों की कृपा रहती है, तो क्या है कि हाँ हाँ हाँ, ओके सर, ओके।
Nitesh ji and Saroj ji, we are good to go. You can start the meeting.
Okay, thank you, Naveen. Nitesh ji, we are starting.
Please.
Good evening, everybody. I am Saroj Swaika, convener of News Exchange Study Circle EIRC. Today's is a very important and hot topic. We are going to discuss on analysis of CBDT circular on section 148. This section 148 is of prime importance for all professionals. Most of us all are confused today about the validity of notices issued by the department. So today we have among us two eminent speakers, namely Dr. Rakesh Gupta, who will be attending and addressing us entirely from US, who is traveling to US today. Among others, we have ex-ITAT member Sushil Pransukhaji. We have among us Advocate SM Suranaji. We have CA Anand Tibrewalji among us, along with all other delegates. I welcome you all on this news platform today. With this, I request CA Nitesh Morji, our joint convener and past chairman of the IRC, to say a few words. Over to Nitesh.
Thank you, Saroj ji. Friends, very thankful to Dr. Rakesh Gupta ji in spite of his busy schedule. He has accepted an invitation, and it is only this seminar was possible only due to his acceptance. Thank you very much, sir. Anand sir, thank you to you and all the panelists who has accepted the invitation. Welcome to you. And now we can. I would request Naveen Khemka ji to kindly introduce the learned speaker, please.
Thank you, Nitesh ji. It's my honor to read the profile of Dr. Rakesh Gupta in front of the August House. Dr. Rakesh Gupta is a high school intermediate and secured merit positions. He stood ranked first in a university in St. John's College in Agra in 1980. He was appointed as member of Income Tax Appellate Tribunal at a very young age of 37 years at Hyderabad. He was co-authored his book with Dr. Rajkumar Agarwal, his co-publisher, the leading publishing house at Taxman, on search and seizure and assessments of search cases and taxation of real estate developers and joint development arrangements. He is currently practicing as an advocate and is appearing in Income Tax Appellate Tribunal, High Courts and Supreme Courts of India. He has argued a lot of high-profile cases of the country at tribunal and high court levels. He has participated in United Nations Committee of Experts on International Cooperations in Tax Matters, held at UN headquarters in New York in April 17 and 19, and a regional headquarters in Geneva in October 18. He has been a member of International Association of Tax Judges and participated in its meetings held at Helsinki, Finland, and Cambridge, UK. He was invited to address Chamber of Commerce and Industry on Finance Bill 2019 in Abu Dhabi and Bahrain. I welcome you, sir, and would hand over the podium again to Nitesh ji.
Thank you, Naveen ji, our the immediate past president of the Views Exchange. We also have another ex-ITAT member. We welcome you, sir. CA Sushil Pransuka, sir. We welcome you, sir. With these, may I now request the learned speaker from the USA, Rakesh Gupta, sir, to kindly start deliberation. We also have, sir, Subhash Agrawalji, learned advocate. If he can start his video. Thank you, sir, for accepting the invitation. It's over to Rakesh Gupta, sir, please.
Thank you, Nitesh ji. A very good morning from US to my esteemed friends and colleagues. Good evening in India. Friends, it gives me immense pleasure and to be with all of you on a topic which has generated heat or which has generated a lot of controversy. And if any one decision of the Supreme Court has generated this amount of heat and controversy in the recent past is the one in the case of Union of India versus Subhash Agrawalji. And I would say and must say that which of the stakeholders has not thrown spanners in this controversy? The SSCs who were issued notices, the High Courts by taking interpretations both way. I mean, though the majority of the High Courts decided in favor of the taxpayer, and then on especially petition by the Supreme Court. And the latest in that list is the Central Board of Direct Taxes by issuing one instruction number 1 of 2022. Though all of those who are logged on are well aware about the controversy, but quickly, if we recapitulate the controversy, that will be good for better comprehension. Notices which were issued under section 148 on or after 1st of April 2021 till 30th June 2021 without undertaking the process of the substituted law, that is under section 148 capital A, when the new law had come to rule. Now, whether were valid or not, this was the precise question which were before various high courts. Now, all high courts except Chhattisgarh High Court ruled in favor of the taxpayers and quashed such notices irrespective of the assessment years, because these notices were not complying with the requirements of section 148 capital A as introduced by the Finance Act 2021. The Delhi High Court gave liberty in the case of Manmohan Kohli to the department to initiate action as per law if it is permissible within the parameters of law in respect of these notices. Revenue could have very well initiated the reassessment proceedings at that point of time, at least for assessment year 2015-16 onwards, subject to the fulfillment of the conditionalities of section 149. But in any case, the limitation for assessment year 15-16 was alive till 31st March 2021. But then the revenue chose to file specially petition before the Supreme Court. I have had the occasion of being one of the parties before Honorable Supreme Court, where Supreme Court was impressed upon. And of course, the Supreme Court got impressed also by the sheer number of the notices which were issued and which were quashed by the High Courts substantially. And Honorable Supreme Court, though have made observations in the order, but then even orally also made observations during the course of hearing, that Supreme Court cannot see these many number of reopening notices being rendered remediless, merely for the reason that the officers under the bona fide belief happened to issue notices under section 148 under the old provisions without being aware that now section 148A now would apply from 1st of April 2021. Therefore, Supreme Court in this decision in Union of India versus Subhash Agrawalji in para number 8 and 10, by invoking its constitutional powers conferred under Article 142 of the Constitution, held that the notices issued under section 148 on or after 1st April 2021 we deemed it to be the notices under section 148A. And then the inquiry is dispensed with. The departmental authorities are obliged to give notices containing the informations which is being possessed by the tax authorities to the assessing officer within 30 days, and thereafter the assessors would respond within 15 days. And then the order under section 148AD would be passed, determining whether it is a fit case for the issue of notice under section 148 or not. And thereafter, this is very important, and thereafter notice under section 148 would be issued in applicable cases. Then all defenses, the Supreme Court held in this very decision that all defenses available to the taxpayers in terms of section 149 as amended by the Finance Act 2021, and kindly mind it, not under as amended by, because section 149 has come to be amended by Finance Act 2022 also, but their lordships were precise in holding that the amended section 149 as amended by the Finance Act 2021 now would be, or the defenses contained in this section would be available to the taxpayer, and the defenses which are available to the tax department by the Finance Act 2021's amended section 149 and in law would be available to the department. Therefore, now there are several issues which arose, and some of those issues were sought to be addressed by the board in its recent instruction number 1. And almost a uniform view now is being expressed in all these deliberations, in all opinions given by the stalwarts, and which are music to the ears of the taxpayers, is that the assessment years 2013, 14 and 14, 15 and even 15, 16 in certain situations become barred. Though the CBDT instruction number 1, 2022, those say that assessment year 13, 14, 14, 15 and 15, 16 have become barred only in those cases where the escaped income amounts to or is likely to amount to less than rupees 50 lakhs. But then in a very large circuit, and the board has said in this instruction about the other notices for assessment year 13, 14, 14, 15 and 15, 16, that they can be reopened by the theory of relate back. Though this theory of relate back is there, but then whether the theory of relate back can be applied, and if can be applied on what basis, what is the rationale and logic, has not been spelled out. And so much so, one thing which is very curious and which has been made reference of Dr. Rajesh Mehra before the beginning of this talk was that, interestingly, surprisingly, curiously, CBDT though has sought to reproduce section 149 in its circular, but has not reproduced the section completely, as if in the opinion of the board, the further reproduction of this section was not required. And I would say that this is a very curious and strange reproduction on the part of that authority which is responsible for the administration of the Act. And in fact, it appears to me, because I have also taken a view so far, that the assessments of assessment year 13, 14, 14, 15 and 15, 16 have become barred. But then on the hint side, while I was again reviewing today morning, then there may be a case, though many of you may not like this changed view, that there may be a very strong possibility of such notices for assessment year 13, 14, 14, 15 and 15, 16 being valid. But then it appears to me, though the department or though the board has conversed or coined the theory of relate back, but then why the theory of relate back should be made applicable now has not been spelled out. And it appears to me very strongly that even the board appears to have missed those points which are in my mind. And since morning, I am grappling with this now, whether on this public platform, I should divulge or I should give that viewpoint in support of the validity of these notices, 13, 14, 14, 15, and 15, 16 or not. Still, when I am talking to you, still I am fighting in my mind as to whether I should speak on that aspect or not. Anyway, I will see, how the things unfold themselves as I proceed. Now, so far as, just a minute, yes. Now, several fundamental issues which need to be appreciated before this question is answered, because most of us are worried, most of us are concerned, and of course as the taxpayers, and of course as the representative of the SSE, as to whether these notices for assessment year 13, 14 or 14, 15 or 15, 16 can be reopened pursuant to the directions of the Supreme Court or not, or they have become barred. As I said a little while ago, and even at the cost of repetition, I would say though the majority of the belief is that they have become barred. And even I myself was the party, because the poster which I sent yesterday late evening from here now also subscribed that view. But today morning, my partner, my junior, very brilliant, Subhash Agrawalji has given me one thought now which has compelled me to think now whether, in the light of this argument which I may share with all of you, now whether the reopening of 13, 14 and 14, 15 and 15, 16, irrespective of the amount involved, can be said to be valid or not. So, but then prior to that, there are certain fundamental issues which need to be dealt and dwelt. The first issue as to which is the precise point of time when the jurisdiction to reopen the assessment is assumed, whether it is at the initiation of the process of 148A or when the notice under section 148 is issued. Of course, there is a difference between the issuance and service, but then the jurisdiction to reopen an assessment now is assumed the moment notice under section 148 is issued. Now, jurisdiction to pass assessment order is assumed when the notice under section 148 is served. And that is what there is a difference between the language of section 149, even the pre-amended law or the post-amendment law, and even the pre-amended law of section 148 and the post-amendment law of section 148. So, jurisdiction to reopen an assessment is assumed the moment notice under section 148 is issued, not at the time when the notice under section 148A is issued or an order under section 148A clause small d is passed. And therefore, the associated question which is very important and equally important is, now limitation to issue notice under section 148 for a particular assessment year now is to be seen in the light of which section. Of course, that limitation is to be seen in the light of section 149 itself, because section 149, if you remember, now even under the pre-amended law and the post-amended law, since we are considering post-amended law of section 149, because the Supreme Court has also said in this decision that no notice under section 148 shall be issued unless these condition of small a, condition of small b, and all the provisos are complied. So, limitation to issue notice under section 148 for a particular assessment year will have to be seen having regard to the amended law of section 149. Then Supreme Court has said that the defense is available to the SSE, as well as the defenses available to the department as per the amended provision section 149 and in law. And that is very important, and in law. Now they are available to both. Therefore, it has to be seen as to what are the defenses, because defenses which have been contemplated under section 149 are many. 149 subsection small a, now it says that no notice under section 148 can be issued beyond a period of 3 years from the end of the relevant assessment year, unless the case falls under clause B. And clause B says that no notice under section 148 can be issued beyond a period of 10 years from the end of the relevant assessment year, unless the assessing officer is in possession of books of accounts, documents, or evidence which suggest escapement of income not less than of 50 lakhs and which is represented by SM. Now, these are very two important qualifying defenses which are available under section 149. But then the defenses do not end at this stage. The defenses go further. And the next defense, which is very important defense, is now whether a case for an assessment year can be reopened as on 1st April 2021 as per the law then existing. Only then that case can be reopened, otherwise that case of that year cannot be reopened. If you remember, the first proviso to section 149(1) that places the overall limit with reference to each assessment year. And so the outer line which has been given by the first proviso to section 149(1) was that as on 1st April 2021, if the case of an assessment year cannot be reopened as per the law which was prevailing as on that date under section 149(1)(b) as then standing. And as then standing was 6 years from the end of the assessment year. Therefore, and as I said, that the board has reproduced section 149 only up to this stage. And it appears to me, and very strongly, as if board is also of the considered view that further provisos to section 149 subsection 1 are of no consequence. Had they been considered of some consequence, then the board would not have curtailed the reproduction of section 149(1) only till the stage of the first proviso. And there it appears to me that even the board appears to have committed error. And I will come to that later. Therefore, CBDT instruction which has been issued now will have to be seen in the light of these issues which have arisen, in the light of the Supreme Court decision, and in the light of the well-established principles of law. So, to what extent can it be said that the CBDT instructions were right to accept the limitation in a selective manner, to say that limitations of 149(1) small a and small b would be applicable, whereas has ignored the first proviso to section 149(1). Then the CBDT instructions is not spelled out as to on what basis, as to on the basis of what jurisprudence the theory of relate back that the limitation will have to be seen with reference to the original notice, though the board has taken this stand, but then has not given any reason. As a student of law, I always believe that whenever you say something, or whenever you conclude something, then you must support that conclusion with the reasoning. Otherwise, I mean, what is the difference between the speaking and non-speaking? This is the only difference between the speaking and non-speaking. When you spell out your conclusion, but without spelling out as to the rationale, justification, jurisprudence behind it, then that becomes a bald statement. That is a different matter, that even that bald statement ultimately may come to occupy the field of law. That is a different matter. But then, as the highest administrative body which is responsible for the administration of the Income Tax Act, ought to have given reason in support of its conclusion that why the theory of relate back based upon these principles, should be made applicable in the present case. But anyway, we'll examine this. Then one thing, which has to be borne in mind is that the notice under section 148 is not mere empty, idle procedural formality. The importance of that notice under section 148 has all along been accorded the status of a notice which confers the jurisdiction. It is not mere issuance of a notice simpliciter. It is a notice which confers jurisdiction. So therefore, the notice under section 148 stands on an elevated high pedestal and status. So any interpretation which have to be seen, which have to be, now that has to be. So first of all, now I will take as to what are the preponderance or the majority of decisions or majority of the opinion and view. Now, and which view is very dear and favorable to the taxpayers and their representative is that the assessment year 13-14 and 14-15 and 15-16, now they have become barred by limitation. They have become barred by limitations because of the operation of the first proviso to section 149(1). Yes, because the assessment year 13-14 could have been reopened up to 31st March 2020 initially. But then because of the extension or pandemic, or because of the extensions given by the pandemic provision, now it was extended up to 31st March 2021. Similarly, assessment year 14-15, the last date for reopening that case was 31st March 2021. And assessment year 15-16, the last date for which was 31st March 2022, now has also gone. Therefore, the preponderance of the view so far is that these assessment years now cannot be reopened, irrespective of the amount involved of escaped income. The board has taken a conscious decision that those cases for these years which indicate the escaped income less than 50 lakhs of rupees, now they should not be reopened. Similarly, the board has taken this view for assessment year 16-17 and 17-18 that these can be reopened based on the theory of relate back. But then 16-17 and 17-18, according to me, can be reopened only if there is escapement of income of 50 lakhs or more and is represented by asset. But then I come to that larger question. Now I'll argue against my initial opinion. Now, as to whether there is a complete denial to the departmental authorities to reopen the assessment for assessment year 13-14, 14-15, and 15-16. Now, kindly see what the Supreme Court has done. Now, Supreme Court has done that the notices which were issued on or after 1st April 2021 under section 148 be deemed to be the notices under section 148A. I'm not saying that this view which I'm conversing is the final view. Who am I to say that I am final? But then this is also the view which the department and including this departmental instruction has not taken so far. Therefore, the notices issued under section 148 after 1st April 2021 till 30th June 2022 on the strength of 149(1)(b) as standing there, then supplemented by TOLA, now have been held by Supreme Court in Ashish Agrawal as a notice under section 148A. And then Supreme Court has given time limit of 30 days and 15 days. And there is a time limit of 7 days in 30 days in 148 AD. Now, therefore, the question comes that the third proviso and the fourth proviso, this is very important, third proviso and the fourth proviso to section 149 subsection 1, now whether would have its field or not. Because third proviso and fourth proviso, which have been omitted altogether by the board in its circular number 1/2022, for inexplicable reasons, they are very important according to me. Third proviso says that the time limit given in the notice under section 148, I don't have the benefit of Income Tax Act here, but the morning which I read, and you may be having, you can take out the note, you can take out your Income Tax Act. The third proviso says the time given in the notice under section 148A small b and the time further sought by an SSE. Now that will be excluded for the purpose of considering the limitation. And fourth proviso says that a time period of 7 days for passing the order. Now that will be given to the assessing officer, and limitation will have to be seen with reference to by giving an additional 7 days to him. These are the cumulative impact of third proviso and the fourth proviso to section 149 subsection 1. Now, what is the effect of Supreme Court's decision? Supreme Court says that the notices should be treated to have been issued under section 148A, and the time now given to the assessees to respond. Now, there is a strong possibility of this interpretation that this entire time period from that time, suppose, let us take an example. So one notice for assessment year 2014-15 was issued on 10th April 2021. Now that notice has been given the status of now notice under section 148A. Now from 148A notice at that stage, till the time the Supreme Court has given 15 days time to the assessees. Now that can be taken to be covered by third proviso to section 149(1). And then fourth proviso says 7 days time for an assessing officer to pass an order thereafter once he receives the reply of the assessee, or the time limit given to the assessee to reply, that expires. So notice issued under section the then 148 on 10th of April 2021. Now was in respect of assessment year 14-15 now could be issued even as per the first proviso to section 149(1), because that sections one that proviso says as per the then prevalent section 149(1)(b), and of course that 149(1)(b) now will have to be read along with the TOLA, because section 3 subsection 1 of TOLA says that wherever any time limit is prescribed for the issuance of notice between this period to this period, then according to TOLA that will be 31st March or the time limit which is prescribed in the notifications issued under TOLA. So the notifications issued under TOLA ultimately gave time limit to the department till 30th June 2021 for assessment year 13-14 of 2014-15 we can take it. Now TOLA cannot be divorced, cannot be discarded, and the view which I have been reading in certain quarters that the TOLA will have to be ignored, because TOLA did not make any distinctions between the old law or the new law. TOLA was applicable in respect of the specified act, and Income Tax Act is the specified act. Now Income Tax Act, there may be some amendment in section 148 or 149, but that is of no consequence insofar as the issuance of notice time limit is extended by TOLA till 30th June. Therefore, the notice in this example which I gave on 10th of April 2021 for assessment year 14-15 read with section 3(1) of TOLA, and kindly mind it, all high courts did not quash section 3(1) of TOLA. Now, what was quashed by all high courts were the notifications, insofar as those notifications were prescribing as to the provisions of section 149 and 151. To that extent, those notifications were found in excess of the provisions of TOLA. So section 31 itself was not quashed, and the notifications were also found ultra vires to this extent that which law would apply cannot be dictated by TOLA. Therefore, first proviso to section 149 subsection 1 read with TOLA now would lend legal credence to all those notices for assessment year 13-14 and 14-15 or 15-16. Let us forget about 15-16 because the time limit in any case was 31st March 2022. So all those notices which were issued between 1st April 2021 to 30th June 2021. Now, even as per the first proviso to section 149, one new section 149, one proviso read with TOLA, now were well within the time. Now, since they were well within the time, Honorable Supreme Court now saying that 15 days time are given to the SSE, therefore the period from that day. Now we cannot be heard saying where was the time given in that notice under section 148A. Now no court can afford to take this interpretation since there was no time given in that notice under section 1, deemed notice under section 148A. Therefore, no exclusion should be provided. No court can afford to interpret that kind of can afford to take that kind of. Therefore, 148A, that deemed notice, now will be deemed to have given time till the expiry of 15 days now, which have been so given by the Supreme Court, and therefore this period will have to be taken out. And then additional 7 days time in terms of fourth proviso now will have to be given to the assessing officer, and then it has to be seen now whether the notice under section 148 which would be issued now is in time or not. So this is very important. Those notices which were issued at the fag end, say on 30th June 2020, because I have seen several notices which have been issued on 30th June 2021 or 29th June or 28th June. Now there, the departmental authorities will have a very narrow timeline because that day notice will be considered in time as per the first proviso read with TOLA. Then up 15 days time, that will be excluded only 7 days time. So when the 15 days time will expire now, thereafter if the departmental authorities take more than 7 days in passing the order, then there may well be the possibility that in those cases, the notice under section 148 is ultimately found to be barred by limitation. Therefore, in my respectful submission, the effect of third proviso, effect of fourth proviso, then the effect of TOLA for the purpose of interpretation of the first proviso to section 149(1), then this time period which has been prescribed by Supreme Court, now they all will have to be taken together, and then will have to be seen whether the notices under section 148 which would be issued henceforward now can be said to be within the time limit or not. So this is my view. It may not be liked by many of us, but then I could not withhold myself from expressing as to what do I believe. It is always very nice to say that all these notices are barred by time, but then I am surprised. As I said a little while ago, and even at the cost of repetition, I would say that at the level of board, to omit the effect of third proviso and the fourth proviso, and not to make any reference to TOLA while giving interpretation of the first proviso to section 149(1) is something which is very astonishing. And the conclusion of the board on the basis of the theory of relate back now is without any ostensible reason. Now that is equally, surprising. So with this, I think I must end my these deliberations, and then we can throw open this entire discussion. To the panelists. Thank you, Nitesh ji.
Thank you so much, sir. I think Hari Ram ji, if we can take questions.
Yes.
So members,
Yes,
if you are having the questions, kindly put in the chat box.
Murli ji ne pucha hai, what is TOLA? TOLA means Taxation and Other Laws, Relaxations of Amendment of Provisions Act 2020. We call it as a TOLA in short.
Friends,
Yeah.
there are a few questions. I am reading one by one, and if it is comfortable to our speaker Rakesh ji, we will be replying those
Yes, sir,
questions.
yes, sir.
First one was,
Yes, sir.
sir, what will be effect of para 104 of Honorable Delhi High Court judgment on 148 notices?
I don't have the benefit of the paras of the Delhi High Court decision, but then if you can tell us as to what is the effect of what is the language of that para, since I am speaking from US, I don't have the necessary wherewithal with me.
So the
Probably
question-
para 104, probably, so far as my memory goes, is with reference to the liberty which Honorable High Court has given to the department to take appropriate actions which are permissible in law. Probably if that is, then the department, instead of taking that liberty to logical end, has chosen to go to Supreme Court, and now everything now is subsumed by the Supreme Court's decision.
Thank you, sir. Second question is,
Yeah.
what about cases where no writ was filed and has already been assessed as returned income or
Yes.
are in appeal?
Yes, you are very right. This is a very unique situation, but then when a power is exercised by the Supreme Court in terms of Article 142 of the Constitution, then all other provisions of law now will have to yield to that. So, since Supreme Court has said that this decision is applicable on pan-India basis, and even the board has also dealt with this aspect of the matter by saying that wherever or whosoever has not gone in writ, now the decision of Ashish Agrawal would apply, and therefore the department will treat, even if those assessments have reached to the finality, would treat all those notices under Section 148 which were issued in particular cases as notices of 148, and then we'll pick the thread from that stage, and then we'll pass the fresh. We'll take these proceedings, and therefore the assessment order which was passed on the earlier occasions based upon the notice under Section 140, that will have to be set at naught. Appellate authority then will hold it as infructuous, or if not infructuous, whatever terminology the appellate authority would choose, but then the net effect of that would be that that assessment is no longer valid.
Yes, sir. Next question is, what about 13-14 and assessment year 14-15 exceeding 15 lakhs or less than 50 lakhs in both the cases?
I think I have already dealt insofar as the board's stand is concerned. The board has taken the benevolence, or board has taken this stand that those which are involving escaped income of less than 50 lakhs, and they would not like to pursue those cases. But then those involving higher amount and represented by SI, that the board is quite keen to take them. And according to me also, in the light of the first proviso read with TOLA, third proviso, fourth proviso, and Supreme Court's decision, that is permissible.
Yes. Next question, whether a fresh notice for reassessment can be issued for the assessment year 17-18, where taxable amount is less than 50 lakhs, in case where no such notice issued previously in old or new Section 148.
Now, regarding 17-18, a period of 3 years have elapsed, but then that 149(1) period will have to be seen again by taking into account the effect of the Supreme Court's decision giving 15 days time now, and then the third proviso, the fourth proviso. Then you should see now whether the 17-18 is a year within 3 years from the end of the assessment year or beyond 3 years from the end of the assessment year. And if it is a case of within 3 years from the end of the assessment year, then 50 lakhs or no 50 lakhs, is of no consequence. But then if it becomes an assessment year which is beyond 3 years from the end of the relevant assessment year, after taking into account all these limitations aspect, then of course 50 lakhs escaped income now would assume importance.
Notice of reassessment issued on 29th June 21 and is still pending for assessment, but not aware about the escaped taxable amount, being reason to believe has not provided till date. What will be impact of Honorable Supreme Court decision?
Yes,
Whether
now
it is time barred or not?
No, in case the assessing officers now, based upon their examination of the record, finds that escaped income is less than 50 lakhs, then they themselves would not go in for it, as board circular says. But then in case they find it more than 50 lakhs, of course, you will be supplied the copy of information, details, evidences, and your response will be elicited. You will come to know.
ASG and department is saying that TOLA has not been held unconstitutional.
Yes, that is what my take is also, that in all those decisions, including Delhi High Court and Manmohan Kohli, TOLA was not held unconstitutional. What was held, that portion of the notifications issued under TOLA, which were in excess of the mandate given under the TOLA, that was to that extent they were held to be bad. So TOLA itself was not held unconstitutional. Who said?
One view is that time barring to be distinguished with Dr. C.A. Dilip Thakkar of Honorable Bombay ITAT.
I mean, jitne log utne interpretations possible. I mean, we are living in free democracy. Who is entitled to hold its own view?
Yes. And the next one is whether a fresh notice for reassessment can be issued for 2014-15 assessment year in case where no such notice issued previously in old or new 148.
No. If the notice has not been issued under section 148 earlier, then there is no question of the Supreme Court's decisions applying to that case, because Supreme Court says that the notices issued within that period will be deemed to be notice under section 148A. So if notice is now issued for the first time, then they are clearly barred by limitation. For the first time, they are clearly barred by limitation, because first proviso to section 149 subsection 1 says that a notice which cannot be issued on 1st April 2021 as per the then existing provision section 149(1)(b cannot be issued now.
Another request is, would you please explain again third and fourth proviso of 149(1)?
Third proviso says to section 149(1) that the time given in the notice under section 148A small b or the time sought by an assessee for giving response to that notice now will be excluded for seeing the limitation. And fourth proviso says that the assessing officers will be given 7 days time to pass an order, and if they take the longer period, then the 7 days time will be excluded for the purpose of limitation. This is the effect of third proviso and the fourth proviso. So in the light of Supreme Court's decision, when Supreme Court says now that 15 days time will be given for an assessee to respond, now this 15 days time, right from 148A, the deeming, now that has to be excluded in my respectful submissions, though, I mean, some of you may hold it differently.
One of our audience is interested to understand why is relate back theory. Sorry, what is relate back theory?
Theory of relate back speaks of certain actions relating back to a particular time point of time. Like I remember, now there was always a question. Now, what is the difference between irregularity and illegality? And Supreme Court, long back in 40 ITR in Guntur brothers case have held that if it is a case of an irregularity, then that irregularity can be cured right from the stage when the irregularity is scrapped. So this is also in a way the theory of relate back, that even if we are making up the deficiency today, but then this making up the deficiency relate back to the original point of time when that deficiency itself is occurred.
Assessee received notice under 148 for assessment year 17-18 for depositing 12 lakh cash during demonetization period. Now, what will happen in this case?
No, I mean, I cannot answer. I mean, this question, there are no dates, there are nothing. So, I mean, this is a very bland kind of a question which cannot be answered in this manner.
Yes, right. Next question is, what about cases where no writ was filed and has already been assessed as returned income or in appeal?
I have already answered
Yeah.
that all these cases where assessments have already been made, I mean, now they are wide open as a result of the Supreme Court's decision being held applicable on pan-India basis.
Supreme Court has said what Delhi High Court has said, then why did they take special power under 148(2)? They could have passed the order in normal way.
Now, I mean, I do not, because I myself was there in the court, I do not want to make any observations with respect to as to what the Supreme Court could have or could not have done, what Supreme Court observed. So we have to go by the decision of the Supreme Court, which are there in the letters before us. So their High Court had said, if the department can initiate fresh proceedings in accordance with law, then, but then had Supreme Court not intervened in this manner, in this way, then the department would have been ousted from its jurisdiction to reopen 13, 14, 14, 15 and 15, 16 at all. Now this department would be able to reopen 13, 14, 15 and 15, 16 because of the Supreme Court deeming 148 notices as 148A notice, and then because of the operation of TOLA in respect of the first proviso, and then operation of the third proviso and the fourth proviso. So without the Supreme Court's decision, the department would have been remediless even then.
So the next question is, I think it is a repetition. Pursuant to CBDT instruction, what stand shall the department take for assessment year 13, 14, 14, 15, 15, 16, both for amount exceeding 50 lakh and less than 50 lakh?
So far as the board is concerned, board has taken this decision that where the escaped income is less than rupees 50 lakhs, they do not want to pursue it. But where the escaped income is more than 50 lakhs of rupees, then the board wants to pursue, and in my respectful submissions, they can pursue.
One view is explanation issued under TOLA extending time limit would be considered valid as the same is questioned by Rajasthan High Court, and Supreme Court has questioned the decision of Allahabad High Court, which was only for notice under 148.
According to my understanding, whichever High Court has dealt with the notification issued under TOLA, none of the High Court has quashed the notifications as such. The High Court has quashed only that portion of the notification which was in excess of the explicit power conferred by TOLA. So we'll have to make this distinction in a very fine manner. Quashing of the notification itself, or the quashing of that portion of the notification which was in excess of the TOLA provision.
Yes, sir. Another is on 31st March 21, a time given under TOLA by 13, 14 and 14, 15 is time barred. 148A did not come into existence. How can that be reopened?
Now, it could have been or it could not have been. Supreme Court has said that notices issued under section 148 between 1st April till 30th June now will be deemed to be notices under section 148A. And in this period from 1st April to 30th June, 148A had come. And then if that had come and Supreme Court has said, then we'll have to accept.
One view is that as per section 24 of the General Clauses Act 1897, notices for assessment year 13-14 and 14-15 can be deemed under section 148A.
That is not, there is no need to go that far. Supreme Court has said, should all those notices be deemed to be notices under section 148A?
It is now assumed that the AO has conducted inquiry prior to issue of deemed notice under 148A.
Yes, that is what Supreme Court has said. Though I would say, with utmost respect and humility, Supreme Court has interpreted the word "if required" in 148 capital A small a, I mean, with utmost humility, erroneously. Because if required doesn't mean that to make inquiry is the discretion of the assessing officer. Because the word "if required," according to our understanding, was as a result of that explanation which is appended below section 148A, that in case of search or in case of the third person, I mean, process of 148 need not be followed. Probably if required was meant for those situations only. But then anyway, I mean, that is neither here nor there. At least for the purpose of this adjudication, the decision of the Supreme Court on the interpretation of the "if required," I mean, is a non-starter. That is of no concern.
Assessment year 13-14 and 14-15 was time barred as on 30th June 21. Can notice under 148 would be issued now, should be valid?
So that I have given the reasoning why notice which would be issued under section 148 now, pursuant to the directions of the Supreme Court. What Supreme Court has said, that notices issued up to 30th June 2021 be deemed notice under section 148A, giving 30 days time to the department, 15 days time to the SSE to respond. Now this period from that day till 15th day of the time expired, now that is liable to be excluded in terms of third proviso to section 149(1).
Yeah. In one of the judgment of Supreme Court, it was delivered to consider the law which was applicable to relevant assessment year. Can advantage of this decision be taken in the case of 13-14 and 14-15?
First of all, now each decision is an authority on its own facts. Now we cannot apply the decisions in a very mechanical manner, and more particularly in the context of today's discussions, we have got now a specific decision given by Honorable Supreme Court, and therefore we have to see now whether the action of the departmental authorities now are within the parameters of that decision or not. I mean, that is the limited aspect which needs to be seen.
Another query is whether only period for issue of notice has been extended or for the completion of assessment has also been extended.
No. Completion of assessment will be governed by section 153. It's only for the purpose of 149. For the purpose of issuance of notice under section 148, this entire discussion is taking place. Once that notice under section 148, which would be issued henceforward, now is found to be within time, then the assessment time period will be governed by section 153. 1 year from the end of the financial year in which the notice under section 148 comes to be served. That is the time limit.
In another question, salary income say 55 lakh, interest income 5 lakh, total income 60 lakh. TDS has been deducted on above income. However, TDS on interest has deducted at the rate of 10%, whereas tax at the rate of 30%. My question is, my income for 148 notice is 60 lakh or 5 lakh?
No. Income, escaped income is irrespective of the tax deducted or deductible. Income escaping assessment means the income which was chargeable to tax and which has not been charged. Merely because the tax has been collected by way of TDS is of no consequence in order to determine the amount of income escaping assessment.
One query is what is asset used under 149(1)(b) of Act? 149.
Now that is $1 million question. Now, when 149(1)(b) says that it should be represented by an asset has been defined under 149 subsection 2, but then that has been defined not in an exhaustive manner. It has been defined in an inclusive manner, and therefore all those species of asset which are of the nature of asset may not find place in the definition can still be included in the definition of asset. But then one thing which I always say, that any income is represented by an asset even for the slightest fraction of time, except where the addition of income is made because of the technical breach, like 222E, like 50C, like 40AIA, like 40A3. Now, except this technical breach, now any income would be represented by an asset in one form or the other, maybe for the slightest fraction of time. Suppose some income is earned. Now, it would be, it may be in the cash, maybe in the next moment, now the cash is spent or the cash goes. But then every income except those incomes, which are the incomes by virtue of the technical breach, now would be represented by an asset, maybe for the fraction of a moment, according to our understanding.
For assessment year 16-17, income sought to escape below 50 lakh. Original notice issued on 23rd June 21. What will be the fate of that case now?
According to me, it will be treated, even having regard to the third proviso, even having regard to the fourth proviso. According to me, 16-17, in the setting of these dates which you have given, maybe an year which falls beyond 3 years from the end of the relevant assessment year, and therefore escaped income which should be represented by asset must be of 50 lakhs or more.
Whether notice issued under 148 after April 21 for assessment year 14-15 will be covered under 148A in view of Supreme Court order?
Yes. That is the first proposition Supreme Court laid down, that those notices in all these cases between this period will be deemed to be notice under section 148.
Order 148A passed on 6th April 22, giving 30 days for assessment year 14-15. Now, what to be done?
Now, I mean, these things cannot be answered in this manner. So, I mean, let us discuss, questions relating to law.
What will be status of return filed in response to 148?
Which 148 you are talking?
What
Now 148 or the old 148? Nothing is clear from your question.
Whether Instru 1 is correct in stating that for assessment year 16-17 and 17-18, specified authority would be under clause 1 of 151, that is PCIT should not be CCIT.
Now, everything will be governed in order to see whether 3 years time period has gone or not. Now, having regard to Supreme Court, this mandate of treating 148 as 148A, 15 days time, then time period which is there under third proviso to 149(1) and 1. And if it is less than 3 years, then the principal commissioner, if it is more than 3 years. So in each case, the computations will have to be done in this manner.
Even we accept the view of department that 148A is live, can it again issue 148 notice in view of 149(1)?
Yes, 148 is to be issued only after 148A process. So when you read 148 now, it says that notice under section 148 shall be issued and it shall accompany the order passed under clause B of section 148A.
Is it to be assumed that now inquiry prior to issue of notice under 148A is deemed to have been completed?
That is what Supreme Court has said. That as a one-time measure, it is dispensed with.
Yeah. Can explanation to TOLA extending time limit be held valid after judgment of High Court, questioning those explanation issued by CBDT?
So I said that I do not recollect any High Court's decision which quashed the notification as such. All that I remember is that all those High Courts have found a portion of that notifications ultra virus to the provisions of TOLA. And therefore, we cannot say in a blanket fashion that High Courts have quashed the notifications as such. So we'll have to read the High Court's decision very carefully.
Yeah. If 148 was issued for loss of 2 crores, can't be said that it backed by asset?
Pardon, kindly repeat your question again.
Yeah. If 148 was issued for loss of 2 crores, can't be said that it is backed by asset for proceeding under Supreme Court direction?
So answer to this question would depend as to what was the nature of that loss. So there cannot be any blanket reply to this, that in case of loss reassessment, it can never be represented by asset. I mean, that is too wide a proposition to which I may not subscribe. So we'll have to see the nature of that loss, and only then the comment can be made.
As the CBDT instruction is silent on the 3rd and 4th proviso to the 149, can those provisions be still applied to justify?
Yes, yes. Law will, I mean, whether the board or whether I, or for that matter, anybody says anything about the law has to operate. There can be no estoppel against law. Law has to hold its own field, irrespective whether it is cited or is not cited.
For assessment year 14-15, notices issued under 148 stating non-disclosure of sale of immovable property of 70 lakhs in ITR. However, capital gain on this transaction rupees 10 lakh. Can this be covered under 149 1B?
No, it cannot be, because what has to be seen is the income, chargeable income, which in your case is 10 lakhs.
Is it mean that no inquiry to be conducted for deemed notice under 148A as per decision of Supreme Court?
For these cases, I think Hariram ji, I think this is 940 और जो पैनलिस्ट हैं हमारे बड़े एस्टीम्ड पैनलिस्ट हैं प्राणसुखा सर, टिब्रेवाल सर, सुभाष अग्रवाल जी, so I think now everybody else should chip in and then.
Yes, correct, sir. So let us conclude this question answer session here so that the another panelist in this panel can start their deliberations. Thank you. Over to Nitesh ji. Nitesh ji, Saroj ji. Nitesh ji, start this second part of this session. Saroj ji.
Yeah, good evening. I think. Yeah, Naveen Khemka ji, if you can start your video. With these, may I now request, first of all, Rakesh Gupta sir, you will be there, na? You will be there.
I'll be there for some time, because then I have to catch the bus.
Yes, yes.
At local time 11:40.
Okay. So may I now request Naveen Khemka ji to kindly introduce the learned panelists, moderators, please. Please unmute, Naveen Khemka ji, please unmute.
Thank you for giving me the opportunity to introduce our panelists today. I would first introduce C. Sushil Pransukha ji. He has qualified as chartered accountant in 1984 and has more than 38 years of professional experience. During his professional career, he has been advisor of different corporates, charitable institutions in the field of direct and indirect taxation. He also advises different corporates on issues like merger, demerger, and business restructuring and taxation implication. He is also expert in family settlements and taxation advisor for family settlement. During his professional career, he was elevated as member of Income Tax Appellate Tribunal. He is past president of Association of Corporate Advisors and Executives and members of different professional associations. He regularly appears before ITAT and other appellate authorities. I welcome you, sir. Next, I would like to introduce our Anand Kumar Tibrewal sir. Anand Kumar Tibrewal sir is a graduate from BCom from University of Calcutta in the year 1969 and was awarded Rector's Gold Medal by City Commerce Group of Colleges for securing highest marks among students from City Commerce Group of Colleges. Post-graduation of MCom from University of Calcutta in the year 1972, he has secured 5th rank in intermediate examination of ICAI held in November 1969 and 1st rank in Eastern India Regional Council. Qualified as Chartered Accountant in May 1972, securing rank among first 50 and joined N.K. Poddar and Company Chartered Accountant as partner of the said firm and practicing as Chartered Accountant since then. Selected as President of Direct Tax Professional Association in the year 2002-03. I welcome you, Anand sir. Now I would like to introduce Advocate S.M. Surana sir. I would just highlight him once.
He's in the panel.
Yeah, I'm just adding him in his screen. Just a second.
Yes, sir. He's in the screen. I had added.
S.M. Surana sir was enrolled as advocate in the year 1967. In profession, he is practicing in Income Tax Appellate Tribunal and High Court. In that connection, he has appeared before Kolkata, Bangalore, Chennai, Cuttack, Ranchi, Patna, Delhi, and Mumbai benches of the tribunal. Many of the cases argued by him have been reported and are available on the sites. He was elected as President of Income Tax Bar Association, Kolkata in 2004-05 and again in 2014-16, as well as the final term in 16-18. He is presently the President of IT Bar Association. He is presently the Senior Vice President of Tax Advocates Association of Bengal. He was toured among the entire West Bengal delivering lectures on taxation matters and has delivered many lectures on the subject. He was the only advocate from outside West Bengal who was nominated Chairman of the Disciplinary Committee of Bar Council of West Bengal, constituted under the Advocates Act for the first time in the year 2008 and 10, and was renominated for the second term of 10 and 12, and again for the third term for 12-14. He was felicitated by the Bar Council of West Bengal in the function organized by the Bar Council in Town Hall in the presence of Law Ministers, Mrs. Chandrima Bhattacharya, Chairman of the Bar Council of West Bengal and Advocate General of West Bengal. It may be noted that Disciplinary Committee is the only authority to take disciplinary actions under the rules and regulations of the Advocate Acts. He is also the Chairman of Taxation and Company Affairs Committee of Bharat Chamber of Commerce, a renowned Chamber of Commerce of Calcutta for more than 15 years. He was honored with Sarupa, the sword, shawl and scarf by Gurudwara Bada Sikh Sangat. He was looked after Jain Svetamba Terapanthi Vidyalaya as President for 2 years, Jain Vishwabharati as Vice President and Senior Vice President from 2006 to 2012. Arbitrator of Jain Svetamba Terapanthi Mahasabha. He is also heading various social and cultural organizations including Manav Seva Sansthan, where poor and needy children are adopted with boarding, lodging and educational facilities, which are provided free of any charge, and has served as President of Sujangarh Nagrik Parishad. I welcome you, sir. Now I would like to introduce Subhash Agarwalji. Just a second.
अभी जो करंट वाला है ग्रुप में करंट वाला
just a second. Subhash Agarwalji is an advocate, a rank holder in LLB examinations held in the Calcutta University in 1992, enrolled as a member of Bar Association in Calcutta High Court in 1999, and started practicing there in civil, writ and taxation matters. At present, he is practicing mainly in income tax litigation field before the CIT appeals, ITAT and High Court, and has also appeared before the Supreme Court on several matters. He has appeared in around 7,500 tax litigation matters in last 20 years, and around 250 matters have been reported in various reputed tax journals and websites. Of late, he has handled various Benami law matters as well. He was elected as a committee member of the Income Tax Bar Association Calcutta twice and also as a treasurer twice. Was elected president of Direct Tax Professional Associations, one of the largest organization of tax practitioners in Eastern India, for the term 2009 and 10. Has written several research articles on taxation, which have appeared in reputed journals like the Chartered Accountant, Taxman, Income Tax Reports, ITAT Online. He has a regular feature, replies on queries on income tax, for continuous 3 years in the ANMI journal, published by the Association of National Exchanges Members of India. He has addressed a large number of seminars on income tax issues on invitations from the bodies like ICAI, Calcutta High Court Bar Association, All India Federal of Tax Practitioners, Direct Tax Professional Association, Income Tax Bar Association, and Commercial Tax Bar Association. He is being regularly entrusted with the task of framing moot court problems and is in the judging panel of the Justice Dr. B.P. Saraf Tax Moot Court competition organized by AIFTP and National University of Judicial Sciences from 2014 onwards, where all the prominent law universities and colleges of the country participate. I welcome you, sir, and welcome all the panelists on board, and would request Nitesh ji to kindly proceed.
Yeah, we welcome you, all of you, sir. It is only due to all of you the acceptance, because all of you have accepted the invitation. We have achieved that 400, 500 even gathering was there. So thank you so much with the folded hands, sir, for accepting the invitation. Welcome all of you, sir. And we are very thankful to Rakesh Gupta, sir. Sir, you had accepted the invitations from the US. So it is the charisma of all of you that the seminar was successful only due to all of you. Thank you so much, sir. With these, may I request Subhash Bhaiya to kindly start the deliberation, the panel discussion.
Good evening, friends. Nitesh ji, thank you so much. I am grateful to Views Exchange Study Circle for giving me this opportunity to moderate the panel discussion titled Analysis of CBDT Circular on Section 148. As we have seen, the discussion had been going on since last 2 hours, which is the entire discussion is an offshoot of Supreme Court decision in the case of Subhash Agarwalji, and consequent upon the rendering of said decision, CBDT has issued SOP in the nature of SOP to the officers. That is instruction number 1 of 2022. I think, friends, panel discussion solely on this instruction is little misconceived. We already had a 2-hour long discussion by the learned speaker, none other than Dr. within bracket CA Rakesh Gupta, advocate, ex-ITAT member, the number of degrees I have lost count of. After such a learned speaker speaks for 2 long hours, so what remains for discussion in the panel discussion? Nonetheless, I have to perform the present task at hand of moderating the panel discussion. I am privileged to moderate a session in which the panel we are having of legal stalwarts of the city, for whom I have great respect and love. Mr. Pransukha is a good old friend and ex-ITAT member. Mr. Tebriwal is an expert in ITA law, and very often we meet at ITAT. And Mr. Surana, from whom I have learned niceties, intricacies of tax laws. Nowadays, we often meet in High Court, particularly since last 3 weeks. It has become a everyday ritual to appear before the tax bench to defend penny stock cases. And Mr. Surana is always fortunate to get 24-karat gold type of cases. So his penny stock cases, the cases he is representing, his client has bought from the PSU is a public sector undertaking. The client has bought from PSU and sold to the PSU. So such cases are bound to, I think, he will have a success in the case. But unfortunately, we are representing cases where offline purchases are made. So initially, the judge was very much against us, but Mr. Surana is magnanimous. He supported and he stood by us like a rock. And if any success comes in, he will have a great role in it. Now, before taking up the discussion, friends, I take liberty from the organizers that only instruction, hardly we can have a panel discussion. So all encompassing the issue relating to the Supreme Court decision and other related issues, we will be having discussion in the panel. So right away, now we should start the discussion. So this question is to all the three panelists, and it may be, the answer may first be given by Mr. Surana. सर कैसा लगा सुप्रीम कोर्ट का जजमेंट, इस पर आप कमेंट करें आप लोग तीनों. सर और ये है कि मतलब क्रिटिकली एग्जामिन करें, क्योंकि राकेश जी हैं and he will concur with me that just criticism of a decision is not amounting to contempt of court. So you kindly critically examine the judge in 5 minutes each.
Thank you, Subhash. And thanks to the office bearers of News Exchange that they given me this opportunity to be with you this evening. Subhash, आपने जो राकेश जी क्वालिफिकेशन बताई उसमें एक क्वालिफिकेशन आप भूल गए. He is very soft at heart, and that's why he is a very, very, very good kavi. And I always get his kavita, his poems in my WhatsApp, and I always read it. I am thankful to him that I am in his WhatsApp group. Now, as you have rightly said, कि राकेश जी ने जब 1-1.5 घंटा 2 घंटा इसके बारे में सब कुछ बता दिया है, तो then what remains to be said? But then, as you said that, what about this judgment of Supreme Court? In my opinion, this judgment should not be criticized at all. People say that somebody should file miscellaneous petition before Supreme Court for clarification and all that. This judgment is completely SSC friendly, because if this is implemented by the department, the SSC is not going to lose whatever he wanted, whatever the SSC wants comes out of the judgment. So CBDT ने जो notification instructions दिए हैं, that is in contradiction with their own Gazetted Officer Association circular. That is that letter given by them to the CBDT that specifically says that no action can be taken for assessment year 13, 14, and 14, 15. That also is Gazetted Officers Association. So how can this CBDT goes against? But as rightly said by Rakesh Ji, theory of relate back. With due respect to Rakesh Ji, in my opinion, theory of relate back in statutory provisions will not go unless specifically retrospective operation is given. And if you see the judgment of J.P. Jani versus some Hindu Bhushan, Hindu Shankar and all that, reported in 72 ITR page 595, there it specifically says that whether some assessment has been barred by limitation or not, you have to see the provisions of the repealed act, not the substituted act. Now, if you see the provisions of the repealed act, which the Supreme Court has explicitly said that the old provisions were substituted by the new provisions from 1/4/2021, and the old provisions goes. So also all the High Court says that from 1/4/2021, substituted provisions will prevail, and the High Courts were correct in holding in 21. Then on 31st March 2021, whether those assessments were barred by limitation or not. And this journey has also been followed in Calcutta High Court judgment in Manikchand Nata 78 ITR page 204. So when something is lost, the provision is dead, then theory of related back might not work. 13, 14 and 14, 15, in my opinion, cannot be reopened in any circumstances by bringing in theory of related back which the CBDT has brought in. But so far as 15, 16 is concerned, again applying those provisions, those case laws, because as on 1st April 2021, the new act came into force, and under the new act, up to 3 years, if it is less than 50 lakhs, and if it is more than 50 lakhs, then more than 3
we will
years.
come to that question, sir. Just briefly, I was saying that Supreme Court judgment kaisa laga?
Right, sir. So in my opinion, the judgment is very good, it's assessor friendly, and one should not panic about the judgment, and one should not think of going for any petition or anything like that for review of the judgment, because if something is mentioned somewhere, it may backfire.
सर ये फिर क्या मतलब हाई कोर्ट इतने सारे हाई कोर्ट ने क्या गलत डिसीजन लिया सर? ये तो हमारे एक मिनट सर, जो सुप्रीम कोर्ट का जो क्रक्स है, व्हाई पार्टली अलाउड द appeal of the revenue was partly allowed. The crux says that in short, high courts ने procedural irregularity को quash कर दिया. Because of procedural irregularity they have quashed, जो कि quash नहीं हो सकता है. जो हम काफी इनिशियल प्रोफेशनल प्रैक्टिस से हम ये सीखते आ रहे हैं कि जहाँ सब्सटेंटिव वायलेशन नहीं होता है वहां पर क्वेश्चनिंग नहीं होता है. तो क्या उन्होंने गलती करी थी?
देखो ऐसे है कि सुप्रीम कोर्ट ने हाई कोर्ट के जजमेंट को कंफर्म किया है, सो फार एज द एक्सटेंशन इज ग्रांटेड अंडर 2 circulars. So they have not said the high court was wrong. What they have simply said is that high court should have given a leeway to the department, because the officers might have made a mistake in applying the old law in place of new law. So they are by coming in between, they have given a leeway by taking Article 142 of the Constitution. This 142 mein they can make a law, they can declare a law, and they have declared the law that a leeway is given, and if this notice under Section 148 can be treated as notice under Section 148. They have taken support from Delhi High Court judgment, that Delhi High Court has also said that the department could have taken action only under the substituted law. Therefore, let this 148 notice be substituted as notice under Section 148.
Sir, लेकिन
so they have confirmed that the High Court judgment.
As I understand, Article 142 is rarely used.
No, it is rarely used, but the Supreme Court at times may use it. And what, see, when you are coming to Article 142, we should read Article 142 again, because what Article 142 says is that if any law is made by the Supreme Court, or any law is law is declared by the Supreme Court, then it has to be implemented by the Parliament or by the President, by the Parliament by making a law, or by the President by notification. So one question came up that whether it will apply to those persons who were not there in the writ. If you read the whole judgment, the judgment gives an idea that it applies only to the persons who filed the writ. In my opinion, to make it a law to apply to everybody, the Parliament or the President has to issue a notification. Otherwise, in my opinion, it may not apply to all the 90,000 cases.
टेबरीवाल जी, आप अपना व्यू दें kindly.
Thanks to Views Exchange. And my view on this issue is that 142 has been used by Supreme Court to say and to make this judgment applicable to all the pending the writs against which the revenue wanted to file appeal, SLP. So they said there is no need of filing appeal. This judgment will be applicable to all the writs, whether the judgment passed or pending. Only to that limited purpose it is 142 has been used. And therefore, I mean, even my opinion is that the law has been declared by the procedure has been declared by the Supreme Court in para 10 of the judgment, and that I mean, the procedure has to be used, has to be applied in all the cases, whether pending, whether any writ was filed or not filed, because that is a law declared by them.
सुशील जी, आप अपना व्यू दें.
First of all, I extend my heartiest thanks to the organizers Nitesh ji, Naveen ji, Khemka, and other office bearers who has given me this opportunity to be amidst the stalwarts of the Professor of Calcutta and Rakesh ji to be a part of the panelist. Regarding Subhash ji's asking from me the view on the Supreme Court judgment, friends, it became as a shock to the department. I'm saying so. Why? That when the initial news came before the order came out in the social media, there was a wide speculation that Supreme Court has used 142 and all cases are gone. So as soon as the order came and I read it, next very day I aired my view that this is not against the SSC taxpayers. This is, as rightly said by Suruna ji also, this is very, very taxpayer friendly and friendly judgment, and all the points have been well taken by the Supreme Court. Maybe that Supreme Court might not have discussed anything about the explanation to the notification, whether ultra vires or not, but has indirectly came to the same conclusion which the High Courts have achieved. So, in my view, High Court judgment is the law of the country. On 141, it is applicable to all the whether file writ or not, whether return was filed or not, as rightly pronounced by the said by the Rakesh ji also, that if any assessment order is also passed, that will also become structurous. So in my view, maybe later in course of our discussion, we will discuss again CBDT instructions also, as and when Subhash ji asked further questions. Till now, my view is that this judgment is very good and true and fair judgment. Thank you, Subhash ji.
सर ये असेसमेंट ईयर 13-14 और 14-15 लीगल एक्सपर्ट्स का पर्सनली भी मेरा भी यही व्यू लग रहा है, डॉक्टर राकेश गुप्ता ने भी यही व्यू दिया कि ये दोनों बार्ड बाय लिमिटेशन है एज पर लॉ, बट सीबीडीटी हैज डेविएटेड फ्रॉम द लीगल ट्रू लीगल पोजीशन. तो 13-14 ठीक है, इसमें तो कोई डाउट नहीं है. 14-15 जो है इसमें थोड़ा सा रीजनिंग में थोड़ा सा मेरा डिफरेंस ऑफ ओपिनियन हो रहा है डॉक्टर गुप्ता से. उन्होंने कहा कि तोला ने ये 13-14, 14-15 दोनों को ही एक्सटेंड किया, बट एक्चुअली ट्रूली स्पीकिंग इफ यू रीड द फाइन प्रिंट ऑफ तोला, उसमें यही बोल रहा है कि इफ वो पर्टिकुलर जिसमें 31 मार्च एक पीरियड उन्होंने स्पेसिफाई किया है, क्योंकि वो ओमनिबस प्रोविजन 3(1) आप देखेंगे तो उसमें बेनिफिट भी दे रहा है. तो फॉर नोटिस पर्पजेज इट इज 31 मार्च 2020. 2020 जहां पर एक्सपायर हो रहा है, लास्ट डेट एक्सपायर हो रहा है 31 मार्च 2020 को, तो उसने एक्सटेंड किया, तोला ने 31 मार्च 2021 एक साल का एक्सटेंशन दिया. फिर बाय वे ऑफ नोटिफिकेशन उसको फर्दर एक्सटेंड किया गया. तो ये 14-15 तो एक्सपायर नहीं हो रहा था. 31 मार्च 2020 को 14-15 एक्सपायर नहीं हो रहा था. कब एक्सपायर हो रहा था? 15, 16, 17, 18, 19, 20, 21, 2021 को एक्सपायर हो रहा था. तो इसमें क्या, इसमें तो एक्सटेंशन ही नहीं हुआ ना, इवन सर्कुलर भी अप्लाई नहीं होगा. 14-15 तो और भी स्ट्रॉन्ग केस बन जा रहा है, क्योंकि ना तो तोला इसका एक्सटेंड कर रहा है, तो तोला नहीं कर रहा है, तो सर्कुलर भी एक्सटेंड नहीं कर रहा है, तो वो वैसे ही 31 मार्च 2020 को नेचुरल डेथ हो गई उसकी. आपका क्या व्यू है सर?
क्वेश्चन किसको है?
क्वेश्चन टेबरीवाल जी जवाब दें इस बार.
मेरा व्यू तो ये है कि वो जो एक्सटेंशन था, the then existing section 148 could have been applied under TOLA event. But now we are under 148A. The notices under 148 would be issued in pursuance to 148A. and not the old act, which was repealed, or I will say it was not in existence for 21. And therefore, even TOLA extension will not apply to those cases. The limitation period will start, will have to be seen from the date when the notice under 148 is finally issued in pursuant to 148A, inquiry or investigation, or an order under 148AT. So that date is particular date, which has to be seen. Limitation period has to be seen from that date. And therefore, I think 13, 14, 14, 15, and even 15, 16 also cannot be reopened.
Sir, I join issue with you. 15, 16 जो है,
हाँ,
उसका 6 years आप ये करें 15, 16 में 50 लाख के ऊपर है तो भी नहीं है reopen,
तो भी नहीं होगा, because 31st March 22 को वो खत्म हो गया under the existing provision of 149.
सर लेकिन काइंडली एनलाइटन मी सर, 15-16 में माने हम अभी तक ये कह रहे थे 13, 14, 14, 15 के लिए कि 149(1) में जो फर्स्ट प्रोविजो है उसको हम इन्वोक कर रहे हैं कि फाइनेंस एक्ट जब से एप्लीकेबल हुआ एज ऑन 1/4/2021, यदि समथिंग हैज एक्सपायर्ड, उसका लिमिटेशन एक्सपायर्ड हो गया तो वो रिवाइव नहीं होगा. दैट स्टैट्यूट आल्सो रिकॉग्नाइजेस. आपका 15-16 वाला जो केस है वो तो एक्सपायर नहीं हो रहा है. 31 मार्च 2021 को वो एक्सपायर नहीं हो रहा है
2021 में. लेकिन अभी जो नोटिस अगर इशू होगी, ये जो नोटिस आप कायम कर रहे हैं 148,
अभी जो नोटिस इशू होगी सर, अभी मान लीजिए आप 5 जुलाई को इशू होती है, 30 दिन का टाइम दिया है. 30 दिन का टाइम दिया, फिर और जवाब में लगेगा टाइम, तो अपने और उसमें जोड़ लीजिए.
तो 15-16 का 6 बरस जो है कंप्लीट होगा 31 मार्च 22 में.
नहीं सर, 22 को हो रहा है, लेकिन यदि उनके पास इंफॉर्मेशन है कि आपने 5 करोड़ रुपया एस्केपमेंट हुआ है आपका, राइट सर?
राइट.
5 करोड़ रुपया यदि एस्केपमेंट हुआ है तब क्या आपको तो तब तो 10 साल आप करंट लॉ यदि लगाते हैं तो 10 साल तक जाएगा.
अगर आप फर्स्ट प्रोवाइजो को देखें, आई रीड द प्रोवाइजो
सर.
प्रोवाइडेड दैट no notice under section 148 shall be issued at any time in a case, at any time की बात है, in a case for the relevant assessment year beginning on or before 1st of April 2021 if such notice could not have been issued at that time. At that time means on the time when the notice is being issued, on account of being beyond the time limit is specified under the provisions of clause B of subsection 1 of this section as they stood immediately before the commencement of the Finance Act 2021. So you have to relate back this period before the amendment came into force on 21. 21 का जो amendment के पहले जो था वो केवल 1 लाख की बात थी, 50 लाख की बात ही नहीं थी, और 6 साल की बात थी वहां. So we have to see that 6 years limitation at the prior to amendment of 2021. We have to see the time limit as prescribed before Finance Act 2021, and that was 6 years only. So if we fall under that, then no notice can be issued, even if the amount exceeds 50 lakhs rupees.
Yes, sir, लेकिन नोटिस तो आज इशू हो रही है ना, जुलाई में इशू हो रही है.
तो जुलाई में इशू
ये बोल रहा है कि प्रोवाइडेड दैट, ये क्या बोल रहा है, इसको यदि सारांश इसका निकालें तो ये बोल रहे कि आज के दिन आप वो नोटिस इशू नहीं कर सकते जो 31 मार्च 2021 में टाइम बार्ड हो गई है. एकदम सिंपल मैनर में हम इसको
ये सुभाष जी, मैं थोड़ा एक्सप्लेन कर देता हूं. जैसे अभी आनंद जी ने पूरा प्रोविजन पढ़ा, यू हैव टू रिलेट नो नोटिस एनी टाइम एट दैट टाइम, यू हैव टू रिलेट एनी टाइम विद दैट टाइम. मतलब अगर आज इशू कर रहे हैं तो पहले वाला प्रोविजन में आपको देखना होगा कि टाइम बार्ड हो गया कि नहीं हो गया, पहले वाला प्रोविजन में. तो मतलब आज 15-16 की हम देखते हैं तो 22 में वो टाइम बार्ड हो गया, 16-17 का 23 में टाइम बार्ड हो जाएगा, 17-18 का 24 में टाइम बार्ड हो जाएगा। सो दोनों प्रोविजन चलेंगे, 6 साल वाला भी चलेगा और 3-10 साल वाला भी चलेगा 27 तक। ये प्रोविजन बिल्कुल क्लियर है मेरे हिसाब से।
नहीं, पर प्रोविजो का यदि मैं सारांश निकालता हूं तो प्रोविजो क्या बोल रहा है, और आप नोटिस तो आज इश्यू कर रहे हैं,
आज जो कर रहे
तो
हैं,
आप ये प्रोविजो को जब आप पढ़
आज
रहे हैं,
हमको देखना है कि 15-16 टाइम बार्ड हो गया कि नहीं हो गया पुराने लॉ के हिसाब से, पुराने लॉ के साथ एट दैट टाइम।
In my opinion, आपको एक चीज देखनी है कि
आवाज नहीं आ रही सुभाष जी।
तो राणा जी आपका कोई इश्यू है वहां पे, थोड़ा आवाज का क्लैरिटी नहीं है।
अगर वो टाइम बार्ड हो गया, बात खत्म हुई। अगर वो टाइम बार्ड नहीं हुआ है तो आज के जो लॉ में वो टाइम में आता है क्या? आई एम सॉरी, अभी आ रहा है क्या? अभी
हाँ बोलिए सर।
क्या नहीं आ रहा क्या भाई?
अभी ठीक
अभी
है।
आ रहा है, बोलिए बोलिए।
आ रहा है क्या आवाज?
आ रहा है, आ रहा है। मैं
ये बोल रहा हूँ कि भाई इश्यू प्रोविजो ये बोल रहा है, इफ नोटिस कुड नॉट हैव बीन इशूड, कुड नॉट हैव को आप जरा समझिए मेरे हिसाब से कि जो 31-3-21 को टाइम बार्ड हो गया है, यानी 31-3-21 के बाद में कोई भी नोटिस आप इशू करते हो टाइम बार्ड हो गया है, उस टाइम में तो आप नहीं कर सकते। लेकिन अगर नए, क्योंकि हो गया उस हिसाब से, अगर नए लोग के हिसाब से टाइम में है और पहले टाइम बार्ड नहीं हुआ है तो ये नोटिस इशू किया जा सकता है। दिस इज माय इंटरप्रिटेशन। जैसा प्राण शुक्ला जी ने कहा या चिब्रेवाल जी कह रहे हैं, उसके हिसाब से जो 22 तक जितने भी 148 होंगे उसमें 6 साल अप्लाई होगा। So that means you are keeping in hand that old law also and new law also.
Correct.
The Supreme Court said both the laws cannot apply. Only the current law will suffice.
सर आपका आवाज में इश्यू हो रहा है, हम लोग समझ नहीं पाए सर।
क्या अभी आवाज सुनाई दे रहा है क्या भाई?
हाँ अभी बेटर है।
ठीक है।
आवाज आ रही है, आपका
मैं ये कह रहा हूँ
होगा बोल करके वो रिले में आ रहा है चीज।
I don't know, there must be some problem somewhere then.
हाँ, इंटरनेट का
सिग्नल वीक होगा आपका।
आप अपना वीडियो सर ऑफ कर लीजिए तो उससे थोड़ी सी क्लैरिटी बढ़ जाएगी।
अब आ रहा है भैया?
अभी तो है, आगे बढ़िए तब पता चलेगा।
ऐसे है कि मेरा इंटरप्रिटेशन ये है कि जो ऑलरेडी 31-21 को डेड हो गया वो रिवाइव नहीं हो सकता, और जो 31-21 के बाद में भी जो अलाइव था उसमें नया लॉ अप्लाई होगा। सिंपल थ्योरी। एंड दिस इज व्हाट आई हैव रेड फ्रॉम द जजमेंट ऑफ जेपी जानी वर्सेस सिंधु भूषण एंड मानिकचंद नाटा वर्सेस इनकम टैक्स ऑफिसर 13। उसमें यही है कि जो आदमी जो 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 एक्शन रिवाइव नहीं हो सकता, वो जो मर गया हो, जो खत्म हो गया, और जो उस टाइम रिवाइव जो जिंदा है उसका, उसमें नया लॉ अप्लाई होगा। इन दैट केस व्हाट हैपेंड in 1961 act, the period of 16 years came, and before that period of 8 years was there, and 8 years period already expired earlier, so 16 years period cannot be availed of even if 16 years period has come, because 8 years period already expired earlier. And in some cases the Supreme Court said where the period was elime, that assessment could have been reopened as on the date when the new law came, then the new law will apply and it can be reopened.
सर लेकिन 15-16 जो है ये तो 31 मार्च 2021 को एक्सपायर नहीं हो रहा। नया लॉ कब आया? 1 अप्रैल 2021 से आया।
मैं यही बोल रहा हूँ, एक्सपायर नहीं कर रहा, इसलिए वो रिओपन हो सकता है अगर 50 लाख से ऊपर हो तो। In my opinion, that can be reopened if it is more than 50 lakhs and fulfills the conditions laid down in section 149(1)(b) of the Finance Act 2021.
चलिए, अपना डिफरेंस ऑफ ओपिनियन रहा इसमें।
डिफरेंस ओपिनियन तो है ही है सुभाष जी। इसमें एक इशू और भी है, 15-16 जैसे मेरा ये व्यू है कि टाइम बार्ड हो गया 22 में, लेकिन एक सिचुएशन है जो राकेश जी ने भी पॉइंट आउट किया और मैं बोला था कि मान लीजिए कि किसी ने रिट फाइल किया और स्टे ले लिया सितंबर में और अभी ये 4 मई को जजमेंट आया, तो ये पीरियड यदि एक्सक्लूड हो जाता है तब तो फिर 15-16 भी खुल सकता है इन दैट सिचुएशन ओनली।
ये इश्यू को हम थोड़ा आगे बढ़ाएं। हम ये बोल रहे हैं जो पीरियड ऑफ जो स्टे है,
हाँ,
वो एक्सक्लूड होगा, है ना। पीरियड
तो
ऑफ स्टे प्लस थर्ड और फोर्थ प्रोविजो की जब बात करते हैं,
हाँ,
तो पीरियड ऑफ स्टे या आपने
140 में आता है
परसुएंट टू 148A आपने कुछ टाइम वगैरह मांगी है, तो वो टाइम एक्सक्लूड होगा। तो चलिए अपने
मांगी है, दोनों चीज है,
हाँ
टाइम और एक्सटेंडेड।
हाँ, तो चलिए एक्सटेंडेड का ही अपने जिक्र करते हैं। तो एक्सटेंड जो स्टे वाला, सॉरी, जो हाई कोर्ट ने स्टे दिया, तो नॉर्मली I had been dealing with lot of writs in Calcutta High Court since inception. तो देखा गया है कि मैक्सिमम 1 आध महीने का स्टे मिला है, क्योंकि उसके बाद दे वर वेटिंग फॉर दिल्ली हाई कोर्ट, कलकत्ता हाई कोर्ट वाज वेटिंग फॉर दिल्ली हाई कोर्ट टू कम। तो उसी पीरियड के लिए तो उन्होंने स्टे दे दिया 1 महीने के करीब का। तो 1 महीना ज्यादा से ज्यादा 2 महीना पकड़ लीजिए, तो 2 महीना जो स्टे का पीरियड है वो कहाँ से रिड्यूस होगा?
सुरना जी बताएंगे। अच्छा, क्योंकि ये बड़ा ट्रिकी इशू है, ये स्टे कहा जाएगा या मतलब सुप्रीम कोर्ट जजमेंट आया 142 में, ये इंटायर पीरियड एक्सक्लूड होगा?
नहीं, इंटायर पीरियड तो एक्सक्लूड नहीं होगा। वी हैव टू गो बाय द प्लेन लैंग्वेज ऑफ द स्टैट्यूट, इसमें कोई कंफ्यूजन नहीं है। तो आपका वो पीरियड का स्टे या इंजंक्शन का जो पीरियड है, वो पीरियड एक्सक्लूजन की
मान
बात
लीजिए
कर रहे हैं।
15-16 का 22 में टाइम बार्ड हो रहा था, किसी ने 1 महीने का ले आया स्टे, तो 1 महीने का पीरियड जरूर एक्सक्लूड होगा और 1 महीने टाइम एक्स्ट्रा जरूर मिलेगा उसको।
नहीं, तो आपको तो जुलाई 22 में वो इश्यू करने वाले हैं, है ना। तो
तो
और
जुलाई में उसमें 1 महीना स्टॉप हो
मार्च
गया
में
ना,
एक्सपायर हो गया, उसको आप बढ़ा दीजिए। आप मार्च की जगह 1 महीना बढ़ा दीजिए तो अप्रैल होता है, 30 अप्रैल होता है। 2 महीना बढ़ाते हैं तो आपका मई तक होता है। 3 महीना बढ़ाते हैं तो जून तक होता है। तो उससे ज्यादा तो स्टे मिला ही नहीं है, एटलीस्ट कलकत्ता हाई कोर्ट में तो मिला नहीं। वी आर सिटिंग इन वेस्ट बंगाल, so let us talk about Calcutta High Court.
That is correct.
If I may explain about this matter,
हाँ,
ये जो टाइम जो है, जो एक्सटेंड होती है डिफरेंस की, ये क्या है कि जिस दिन नोटिस इशू होनी है 148 की, सपोज द टाइम बारिंग लिमिट टाइम इज अप टू 31 मार्च 23, तो उसमें क्या है कि ये जो पीरियड है बिटवीन 20 दिन का हो या 1 महीने का हो या 2 महीने का है, वो उससे वो एक्सटेंड होके मार्च की जगह वो मई चला जाएगा। That means the notice which could have been issued before 31st March was the last date could be issued up to 31st May because of this time lag, जो 2 महीने का टाइम मिलता वो एक्सटेंशन मिल जाएगा। This is what is the meaning.
ये अपने सुशील जी भी यही बात बोल रहे हैं, और हम लोग इसी पर इसमें कंकरेंस है। सुराना जी भी आई थिंक विल एग्री दैट। तो इसमें इन अदर वर्ड्स वी कैन से, जो आप अभी तक सुराना जी और सुशील जी का व्यू था कि दिस जजमेंट इज ब्लेसिंग इन डिसगाइज, अच्छा जजमेंट। तो देयरफॉर अभी यही व्यू ले रहे हैं। तो यहाँ पर प्रैक्टिकली वी कैन फाइंड कि अब ये दे दिया कि आपको मतलब जुलाई तक टाइम डिपार्टमेंट को इश्यू करने का दे दिया। तो ये जो आपका अप्रैल से जुलाई का जो गैप है, उसको आप रिड्यूस करेंगे तो कितना रिड्यूस करेंगे? 1 महीना 2 महीना जो स्टे का पीरियड रिड्यूस करेंगे। स्टिल माने बिकॉज ऑफ दिस सुप्रीम कोर्ट जजमेंट मेनी केसेस विल कम आउट ऑफ द नेट ऑफ बार्ड वाई लिमिटेशन होके इनके क्लचेस से बहुत सारे केस बाहर आ जाएंगे। सुराना जी, एनी अदर व्यू ऑन दिस, और यू कंकर विद दिस व्यू?
I concur with this view. मैंने तो बोला ये पहले भी।
जी सर। अब अपने आते हैं 16, 17, 17, 18 तो ये सब में आई थिंक देयर शुड नॉट बी एनी क्वेरल बिटवीन अस कि ये 50 लाख के नीचे है तो आप नहीं रीओपन कर सकते, 50 लाख के ऊपर है तो आप
कर सकते हैं।
सर अब ये क्वेश्चन मैं सुराना जी से पूछूंगा कि सुराना जी को आजकल हाई कोर्ट में बहुत देखा जा रहा है, तो हाई कोर्ट रिलेटेड क्वेश्चन है तो सुराना जी से ही पूछूंगा। सर ये जो 13 डिपार्टमेंट का जो सर्कुलर आया है उसमें ये जो लीगल व्यू है वो मानने को तैयार नहीं है। 13, 14, 14, 15 में एटलीस्ट कंसेंसस है amongst all the legal experts कि these are barred by limitation as per law. तो इसमें what will be, क्या second writ will be the better remedy or pursuing the alternative remedy will be the better remedy?
My opinion, second remedy ज़्यादा, first remedy ज़्यादा better है. If any notice comes for 13, 14, it is better to go straight way with it.
केजरीवाल जी आप
तो मेरा तो व्यू ये है कि वी शुड प्रोसीड इन ए रेगुलर मैनर इंस्टेड ऑफ गोइंग फॉर इट। आप रिट फाइल करेंगे फिर कोई आ जाएगा लीवे।
सर हाँ, ये इस इश्यू पर मैं कुछ कहना चाह रहा था, इसीलिए आई प्रोवोक्ड यू टू आंसर दिस क्वेश्चन। मैं ये कहना चाह रहा हूं सर कि लॉ ऑफ लिमिटेशन को लेके क्या सुप्रीम कोर्ट टिंकरिंग कर सकता है क्या? एज्यूमिंग कि आपका क्वैश हो गया इस ग्राउंड पे, तो मेरे ख्याल से तो ये फिर तो मतलब लगेगा कि यार हम कहाँ रह रहे हैं।
देखो लॉ ऑफ लिमिटेशन में अभी सुप्रीम कोर्ट का जजमेंट आया था ना नेशनल कमोडिटी एक्सचेंज का 2 महीने पहले। दे से वी हैव नो राइट टू एक्सटेंड द लिमिटेशन इन एनी सर्कमस्टेंसेस, और इसीलिए सुप्रीम कोर्ट ने इस जजमेंट में लीवे बोल के निकाल दिया है। अदरवाइज सुप्रीम कोर्ट हैज जस्टिफिकली सेड दैट वी हैव नो राइट टू प्ले विद द लिमिटेशन. Limitation provisions has to be completely followed and has to be given effect to. The judgment is sometimes in January.
अब आगे बढ़ते हैं सर। एक अच्छा मुद्दा जो है, जो हमारे जो ऑडियंस है उनके लिए भी फायदेमंद होगा। एक प्रश्न ये है कि वी नो द स्नेल स्पेस एट विच द डिपार्टमेंट वर्क्स। तो सर ये जो 30 दिन का जो डेडलाइन जो सुप्रीम कोर्ट ने दिया है, पहला क्वेश्चन तो ये है कि ये 30 दिन का डेडलाइन यदि ब्रीच होता है तो लीगली क्या सिचुएशन पे हम पहुंचते हैं, और दूसरा क्या पॉसिबिलिटी है कि सुप्रीम कोर्ट इसको माने डिपार्टमेंट वापस जाके सुप्रीम कोर्ट से एक्सटेंड करवा ले। Any panelist can answer this.
देखिए ये तो टाइम तो एक्सटेंड सुप्रीम कोर्ट के अलावा और कोई कर नहीं सकता। हाँ ये पॉसिबिलिटी है, अगर इनके दिमाग में ये चीज हो जाकर सुप्रीम कोर्ट के पास जाए और बोले कि मेरा टाइम बहुत शॉर्ट एक्सटेंड कर दीजिए, तो दैट मे बी ए पॉसिबिलिटी, बट अदरवाइज डिपार्टमेंट कैन नॉट सो मोटो एक्सटेंड दिस टाइमलाइन।
देखो जहाँ किसी पे मेहरबानी की है ना रेवेन्यू पर सुप्रीम कोर्ट ने कि चलो तेरा 148 कर लेते हैं, आप अब दे दो, आपको 30 दिन का टाइम देते हैं। अब अगर वो जाएंगे ना तो अब कोई लीवे नहीं मिलने वाली है।
हाँ
फिर तो यही होगा, सुप्रीम कोर्ट भी चिढ़ जाएगी कि आपको इतनी अपॉर्चुनिटी दे दी, इसके बाद में भी आप मांग रहे हैं और टाइम। अब अगर कोई भी सुप्रीम कोर्ट में जाएगा डिपार्टमेंट की तरफ से कोई भी बात को लेकर के, टेक इट फॉर ग्रांटेड, ये बैकफायर करेगा।
राइट, 100% एग्री।
So in other words, you mean to say litigation is always beneficial to the SSC?
No, I don't say that, but if
ये 30 दिन का तो एडिशनल मिल गया ना सर आपको ग्राउंड।
Department wants to put you in litigation, then you have to.
हाँ नहीं, माने ये आप लिटिगेशन के वजह से एक नया आपको एंगल मिल गया, आप एक ग्राउंड में एक एडिशनल ग्राउंड ये भी लेंगे।
The earlier notices under section 148, then the High Court judgments, then this particular circular, these are all made for the professional. Neither the department is going to gain anything, nor the SSC is going to gain anything. Only benefit is to the professional. Ultimately, the SSC will get the rate.
तो मेरी समझ से जो 30 दिन की जो बात है वो किस लिए सुप्रीम कोर्ट ने कहा, क्योंकि 148A(b) में पहले भी था, माने बिफोर 148A came into force, कि the assessing officer has to provide to the assessee the information. अभी पहले रीजन था, अब आ गया इंफॉर्मेशन आ गया है, and also the materials and documents evidencing the escapement of income. Now पहले था जीके एंड डैश में था, उसके बाद कोर्ट्स का इंटरप्रिटेशन हुआ, अब उसको इन लोगों ने 148A में डायरेक्टली लिया. Now the Supreme Court has given this time of 30 days to the department that you should provide to the SSE, because this 148A की जो नोटिस को उन्होंने deemed किया है 148 नोटिस को, so they have given the time to the department that within 30 days you supply, you furnish the copy of the information as well as the evidences and documents which pertains to escapement of income. So ये time उसके लिए दिया गया है. And if they fail to do so, it's a direction of the Supreme Court, mandatory requirement of law, I will say. If they fail to do so, the assessment, the notice issued in pursuant to such proceeding is have to request.
अगेन सर, उसमें क्या रीट रेमेडी बेटर होगा या ऑल्टरनेटिव?
रीट में देखिए, one do not know how the court will act. हो सकता है वापस भेज दे उसको, बोले कि तुम अब इंफॉर्मेशन दो.
सुप्रीम कोर्ट के मैंडेट के अगेंस्ट में?
हाँ, अब रीजन्स की बात है. रीजन्स की, once you have applied for the regions, पहले क्या था? You have applied for regions not furnished. Some courts have said that okay, now you give the regions, let them file the objection.
मेरा नेक्स्ट क्वेरी है सर, ये जो इंक्वायरी वाला जो 148 में जो प्रोविजन आया सर, ये तो पहले से ही ये लॉ थी. दिल्ली हाई कोर्ट, सुराना जी, अग्रवाल जी, हम लोग सबने उसको यूज किया. दिल्ली हाई कोर्ट के नंबर ऑफ डिसीजंस, अतुल जैन 299 ITR, SFIL 325 ITR, वर्षा बेन, सनत भाई पटेल, गुजरात हाई कोर्ट, ये सबने कहा कि इंफॉर्मेशन बेस्ड यदि रीओपनिंग होता है तो यू हैव टू मेक इंक्वायरीज एंड देन प्रोसीड विद इट. तो सर ये क्या गलती हो गई कि हमारे जो लॉयर बंधु जो थे सुप्रीम कोर्ट में, उन्होंने ये सब जजमेंट साइट नहीं किया? ये जजमेंट साइट होने से शायद क्या व्यू डिफरेंट होता? नंबर 1. नंबर 2, कैन वी स्टिल रिलाई ऑन दीज डिसीजंस कि ये जो इंक्वायरी जो है क्या ये इम्प्लाइडली ओवररूल्ड हो गए बाय वर्च्यू ऑफ सुप्रीम कोर्ट डिसीजन इन आशीष अग्रवाल? और यहाँ पर क्या थर्ड क्वेश्चन ओरिजिनेटिंग फ्रॉम द फर्स्ट 2 क्वेश्चंस, 148 कैपिटल ए स्मॉल ए में they have used the word conduct inquiry if required. तो law itself has diluted it. ये जजमेंट क्या ये लेगा कि हमको इंक्वायरी करना है कि नहीं, if वो रॉन्ग जजमेंट लेता है? if the facts demonstrate कि inquiry was necessitated but he does not make inquiry, can we before appeal court or any other court, can we take the plea that
आप एक चीज देखो, पहले पैरा 8 देखो, उसका सुप्रीम कोर्ट का जजमेंट, उसमें जो प्रपोजल दिया है कि दिस इज ऑर्डर वी प्रपोज टू पास, उसमें ये 148A की इंक्वायरी इफ रिक्वायर्ड को डील नहीं किया सुप्रीम कोर्ट ने. सो दिस नेवर केम अप फॉर डिस्कशन बिटवीन द लॉयर्स. दिस इज सुप्रीम कोर्ट हैज प्योमोटो गिवन दिस. इफ रिक्वायर्ड का मतलब आईटीओ की इच्छा है तो करेगा, ऑफिसर की इच्छा है तो इंक्वायरी
करेगा. लेकिन स्टैट्यूट में लिखा हुआ है सर, सुप्रीम डॉक्टर राकेश गुप्ता ने कहा कि सुप्रीम कोर्ट ने फर्स्ट टाइम ये यूज किया है. आई एम सरप्राइज्ड, लेकिन सुप्रीम कोर्ट हैज नॉट डन इट सुओ मोटो. इट इज द लैंग्वेज ऑफ द स्टैट्यूट. 148
नहीं, आपने ये कहा कि जो लॉयर थे उन्होंने ये सारे जजमेंट दिखाए क्या? ये फर्स्ट प्रपोजल जो पैरा 8 में दिया है प्रपोजल, उसमें ये इफ रिक्वायर्ड वाली बात, इसका इंटरप्रिटेशन की कोई बात नहीं थी. ये पैरा 10 में सुप्रीम कोर्ट ने जजमेंट देते वक्त इसको ऐड कर दिया है. दिस इज नंबर 1. नंबर 2, 148A को आप जब बिगिनिंग से पढ़ोगे तो उसमें लिख रखा है कि असिस्टेंट ऑफिसर shall, उसके बाद में A में लिखा है if required. ऊपर में word shall है और A में आया है if required. So in my opinion, at the appropriate time, it has
Sir,
to
I'm reading for the benefit of all. 148A says the AO shall, before issuing any notice under section 148, उसके बाद A, B, C, D है. तो ये shall word है, ये सबके लिए है, लेकिन A में further qualification है कि conduct any inquiry if required.
Yes.
तो बाकी shall provide opportunity of hearing, shall consider the reply of SSC, shall decide the on the basis of material available on record. लेकिन जब अपने वो A में आते हैं, तो shall conduct inquiry if required. That makes the complete sentence.
Yes. That
तो
makes
इसे
the complete
dilutes
sentence.
कि वो
No doubt
AO का
about that.
discretion है. That will be the version of the department. ये AO का discretion.
You see, when the full materials are not there, information is there. पुराने केसेस में सब में क्या डिसीजन हुआ? यही तो है ना कि the AO had simply received the information, he has not made the inquiry. Therefore, he should have made the inquiry. So, in cases where full information, select information doesn't reflect the actual statement of income, then the inquiry is required to be made. And that interpretation given by the Supreme Court can be considered as obiter dicta because they were not required to pass this order at this stage. At the appropriate time, it will be taken up.
A logical inference can be drawn from. I am playing devil's advocate today. तो तभी आप लोगों से ज्ञान की बातें निकाल पाऊंगा. तो ये मतलब रेवेन्यू विल से कि यहाँ तो अब लॉ डाइल्यूट, पहले ऐसा कोई लॉ था नहीं. अब ये जो है हमारे फेवर में ये लॉ बना है, इसमें बोल रहा है कि ये एओ का डिस्क्रिप्शन है, जरूरत हुआ तो इंक्वायरी करेगा. तो और दूसरा बात जो है, सुप्रीम कोर्ट ने खुद कहा है कि ये एक प्रोसीजरल जो कि वेल सेटल्ड लॉ है. इस पर किसी का भी अपने जो यहाँ बैठे हैं किसी कोई भी इसमें डिबेट नहीं है इस इश्यू पर कि प्रोसीजरल लॉ में कुछ इरेगुलरिटी होती है तो द ऑर्डर कैन नॉट बी क्वेश्चन प्रोसीजर में. तो यहाँ पर ये लॉ इटसेल्फ सेज कि इंक्वायरी टू बी डन इफ नेसेसरी, और नहीं किया इंक्वायरी तो उसमें ज्यादा से ज्यादा सुप्रीम कोर्ट ने तो यही कहा कि ठीक है हम वापस भेज रहे हैं, इंक्वायरी कर लो. उसके लिए नोटिस, हाई कोर्ट को नोटिस क्यों क्वेश करना था? आगे बढ़ते हैं सर. एक हमारे मित्र ने डॉक्टर राकेश गुप्ता से एक क्वेश्चन किया, इफेक्ट ऑफ पैरा 104 ऑफ दिल्ली हाई कोर्ट. तो अनफॉर्चुनेटली डॉक्टर गुप्ता के पास वो था नहीं जजमेंट, बट वी हैव दैट डिसीजन विथ अस. 104 इज अबाउट द क्वेश्चनिंग. डॉक्टर गुप्ता said he missed this particular para altogether while studying the decisions, क्योंकि ये क्वेश्चन भी उठा था कि ये जो एक्सप्लेनेशन जो दो नोटिफिकेशन थे 31 मार्च और 27 अप्रैल 2021 के, उसके नीचे में जो एक्सप्लेनेशन था जिस बाय वर्च्यू ऑफ दैट द सेंट्रल गवर्नमेंट वाज एम्पावर्ड टू एक्सटेंड द लिमिटेशन पीरियड, वो नोटिफिकेशन का सुप्रीम कोर्ट डिसीजन का क्या इम्पैक्ट है और ये क्या वेदर हाई कोर्ट्स ने इस पर कुछ टिप्पणी करी है. तो दिल्ली हाई कोर्ट पैरा 104 में क्लियरली सेज दैट दीज नोटिफिकेशंस आर डिक्लेयर्ड अल्ट्रा वायरस द तोला एक्ट एंड देयरफॉर बैड इन लॉ एंड नल एंड वॉइड. इन क्लियर टर्म्स में दीज नोटिफिकेशंस हैव बीन क्वेश्चन्ड. तो ये इसका क्या इम्पैक्ट है सुप्रीम कोर्ट डिसीजन, ये जो पर्टिकुलर पैरा ऑफ दिल्ली हाई कोर्ट है आफ्टर सुप्रीम कोर्ट डिसीजन, whether this particular part of decision of Delhi High Court still holds the field?
In my opinion, it still holds field because Supreme Court has agreed, accepted the contentions of the different high courts. The high court's orders have been approved by them, but give a leeway to the revenue only. They have said that the notice under 148 should be treated as a notice under 148A.
This is courts, high courts have rightly said. This is the
Rightly
word,
said.
this is the word used.
So these will still hold good.
अच्छा, सुप्रीम कोर्ट जो है बार बार रेफर कर रहा है फाइनेंस एक्ट 2021, तो वो इट एज्यूम्स ग्रेट सिग्निफिकेंस इन द लाइट ऑफ द फ्रेश नोटिसेस दैट विल कम, क्योंकि फ्रेश नोटिस में आपका जो करंट एक्ट है, क्योंकि हम देखें जो नोटिस में यदि हम उसका सर्वे करते हैं कि किस टाइप की नोटिसेस इश्यू हो रही है, 148A या 148 रीओपनिंग किस लिए हो रही है, ऑलमोस्ट 90% आई थिंक इज बिकॉज ऑफ सेक्शन 68। तो जब सुप्रीम कोर्ट फाइनेंस एक्ट 2021 की बात कर रहा है, तो उसमें दोज आर नॉट कमिंग अंडर द क्लचेस ऑफ लॉ, क्योंकि उस समय एसेट की, हालांकि आई जॉइन इश्यू विद डॉक्टर गुप्ता ऑन दिस। डॉक्टर गुप्ता ने कहा कि इंक्लूसिव डेफिनेशन ऑफ एसेट है, बट प्रिंसिपल ऑफ एसेट एजेस्डम जूरिस जो एक एजेस्डम जेनरिस जो प्रिंसिपल है कि अ वर्ड टेक्स इट्स कलर फ्रॉम द कंपनी इट कीप्स, तो यहाँ पर वो जो इंक्लूसिव डेफिनेशन होते हुए भी इट टॉक्स अबाउट द टेंजिबल एसेट। 69 का जो एडिशन होता है उस एसेट के बारे में बात हो रही है। तो देयरफॉर ये जो है आपके एंट्रीज इन द बुक्स, credits in the books, they, in my opinion, it will not be covered. Though, in my opinion, this is an inadvertent error of the Supreme Court, क्योंकि ये आपका तो जजमेंट आया है मई में, तो the difference of time is very little. एक्ट आपका मार्च में 22 एक्ट इनंसिएट हुआ है, तो जो वहां पर मेरे ख्याल से जज साहब के पास थोड़ी इतनी टाइम रहती है कि किताब खोल के करंट क्या लॉ है, और रेवेन्यू लॉयर में हैव आल्सो मिस्ड दैट। तो ये एक एडवांटेज अपने को शायद मिलेगा।
सुभाष जी, ये एडवांटेज मिलेगा तो ये सीबीडीटी का जो इंस्ट्रक्शन है उसमें जो 149 उन्होंने छापा है, वहां पर भी उन्होंने रिप्रेजेंटेड बाय एसेट वाला ही एक्ट छपा है जो 149,
क्योंकि वो तो सुप्रीम कोर्ट के इतना तो उन्होंने रिस्पेक्ट दिया है सुप्रीम कोर्ट को।
हाँ,
वो कि उन्होंने मतलब सुप्रीम कोर्ट के बियॉन्ड उन्होंने कोई भी व्यू नहीं लिया।
सो इंट्रीज वाली बात उसमें नहीं आएगी एस्केपमेंट ऑफ 50 लाख वाले में। ओनली एसेट शुड बी देयर रिप्रेजेंटेड बाय द एसेट।
सुराना जी,
उन्होंने देखिए पैरा 6 में जो इंस्ट्रक्शन है उसमें भी उन्होंने फाइनेंशियल 2021 की बात ही लिखी है।
हाँ,
और फाइनेंशियल 2021 की बात इसलिए भी लिखी है वो क्योंकि सुप्रीम कोर्ट के सामने जो नोटिस थे वो 1/4/2021 से 30/6/2021 वाले थे, तो those were all governed by financial 2021. So what the Supreme Court has said, so also the circular rightly said that only financial 2021 में जो
सुप्रीम कोर्ट उतनी दूर की नहीं सोच पाया कि वो जो 2022 में जो अमेंडमेंट हुआ है इसको
वो एक्चुअली दूर की सोचने की बात नहीं, उनके सामने डिस्प्यूट भी वही था कि ये जो नोटिस है इस पीरियड में गए हुए हैं वो वैलिड है कि नहीं है, तो उस डिस्प्यूट में फाइनेंशियल 2021 ही अप्लाई कर रहा था। और असेट में भी आप देखिए कि एक वर्ड यूज कर रखा है, मान the escape income it should be revealed from the books of accounts, information and evidences. तो ये वर्ड रिवील है ना, रिवील means something which was kept secret. That means the asset as well as the escape income both were kept secret. My humble opinion it should be there. ये नहीं है कि साहब असेट रिप्रेजेंट कर रही हो तो कोई आपकी एस्केप इनकम है, एसेट से तो मिलेगी, so even if the asset is disclosed but the income is not disclosed, this provision will apply. In my opinion, that will not be a correct interpretation.
And I think this has been answered by in the Guwahati Tribunal's judgment. 2 judgments are there by Mr. Varki. What is the meaning of the asset, revenue by income, etc. There are 2 judgments of Guwahati Tribunal.
कलकत्ता आईटीटी का भी है ना, गोल्ड स्टोन।
कलकत्ता का क्या, तो एक तो कलकत्ता का और गुवाहाटी का, 2 जगह है।
कलकत्ता का ही है
वो गोल्ड वो अपने वो गोयल जी उसको साइट करते हैं।
हाँ, 2 डिसीजन थे ना उसमें।
क्या पूरा नाम क्या है तो सबके
तो
बेनिफिट?
गोल्ड स्टोन है एक नाम, तो और दूसरा नाम क्या है?
ये तो उसमें गूगल में गोल्ड स्टोन प्लस वर्की करने से मिल जाएगा।
हाँ हाँ
हाँ हाँ मिल जाएगा, मेरे पास, मैं भेज दूंगा, साइटेशन है मेरे पास उसका।
नहीं, मैं ऑडियंस को
एक तो है फॉर्चून वाणिज्य प्राइवेट लिमिटेड।
जी सर।
फॉर्चून वाणिज्य प्राइवेट लिमिटेड गुवाहाटी आईडीटी का है, और दूसरा है गोल्ड स्टोन सीमेंट लिमिटेड। आई थिंक दिस इज
फॉर्चून वाणिज्य प्राइवेट लिमिटेड,
वाणिज्य प्राइवेट लिमिटेड,
बोथ बाय वर्की।
बोथ बाय मिस्टर वर्की।
नितेश जी, व्हाट इज द सिचुएशन? हम लोग तो सोच रहे थे कि कितना डिस्कशन कर पाएंगे
सर चलिए, कोई
सुनने के बाद, लेकिन अभी भी करीब
हाँ करिए सर, कोई दिक्कत नहीं है।
350 हैं ऑडियंस में।
हाँ हाँ, और दे आर ईगर
रात
टू,
होने के
दे आर
बावजूद।
ईगर टू सर। आप लोग चलाइए, 9 साढ़े 9 बजे तक चलाइए आराम।
नहीं तो ऐसा मत करिए सर, हम लोग
नहीं, मैंने आप लोग की जैसे इच्छा हो।
एक बात मैं बोलूंगा इसमें रिगार्डिंग ये जो बात थी कि 2021 की बात क्यों हुई, इसमें 2022 का अमेंडमेंट क्यों नहीं आया। सर उन्होंने क्लियर किया कि जो नोटिसेस 2021-22 तक है वो तो उस एक्ट में होगी, उसके बाद में होगी, वो अमेंडेड एक्ट में आएगा प्रोविजन में। सो क्लियरली दे मीन टू से इट कैन नॉट बी रिट्रोस्पेक्टिव। No notice for the assessment, relevant assessment year beginning on or before 1st April 21. उसमें वो 21 का एक्ट लगेगा।
पर सर ये जो 148 प्रोसीडिंग जो होती है, तो जिस दिन नोटिस इशू हुआ उस समय की लॉ लगेगी?
अब तो मैंने इसने क्लैरिफाई कर दिया भाई, इसमें सुप्रीम कोर्ट जजमेंट नहीं, so we need not go into that aspect, to see into that aspect, because it says on any notices issued prior to the assessment 21-22 up to 21-22, the old section 149(1) has to be seen.
ये लिखा है?
हाँ हाँ एकदम एकदम।
कहाँ पे?
Should I read once again?
हाँ नहीं, वो पैरा
provided that no notice under 148 shall be issued at any time in a case for the at any time की बात what you ध्यान दीजिएगा, at any time for the relevant assessment year beginning on or before 1st April 21. If such notice could not have been issued at that time on account of being beyond the time limit specified in the 149(1)(a), 1b, as they stood immediately before the commencement of the Finance Act 2021.
ये तो सर लैंग्वेज है, स्टैट्यूट की लैंग्वेज।
मैं वही लैंग्वेज पढ़ के बता रहा हूँ आपको।
सर ये आई थिंक अब कुछ some people are eager, some of our friends are eager to have their individual queries answered. क्योंकि चैट बॉक्स में कंटिन्यूअस कुछ क्वेरीज आ रही हैं, तो कैन वी हैव सम queries answered by the panelists? ये सुधीर अजीत सरिया जी बोल रहे हैं, कैन वी प्लीज हैव ए कमेंट ऑन व्हाट श्री राकेश गुप्ता deliberated that all notices are valid? ऐसा शायद नहीं कहा है उन्होंने, ऐसा तो नहीं कहा है कि सब नोटिस वैलिड है।
आई थिंक उन्होंने क्या कहा है, he can go through the video, the video is there in the YouTube channel, so that video is there and he can go through the video also.
I think everyone has got his own opinion in interpretation, and therefore I think there should not be any comment on the observations made by any person at this stage.
नो, यहाँ पर कमेंट नहीं है सर, यहाँ पर इन्होंने शायद ठीक से सुना नहीं, मिस इंटरप्रेट कर लिया, इसलिए, क्योंकि देखिए इस चीज में तो हर आदमी पैनिक खाएगा ना कि हर नोटिस, वो यदि मेरे को ये इंप्रेशन मिले कि हर नोटिस वैलिड है तो आई विल आल्सो गेट पैनिकी, और एक बहुत लर्नेड स्पीकर से कोई मिल रहा है तो ऐसा नहीं है सर, उन्होंने ये नहीं कहा है, एटलीस्ट 2 साल के लिए तो उन्होंने ये क्लियर कट, उनका भी यही व्यू था 13-14, 14-15 की दीज नोटिसेस आर इनवैलिड। बाकी में सब्जेक्ट टू कंडीशंस कि वो 50 लाख वाला, वो खाली वो बोल रहे थे कि आपका जो थर्ड प्रोविजो और फोर्थ प्रोविजो को भी कंसिडरेशन में लेना होगा टू डिटरमाइन वेदर द नोटिसेस आर वैलिड और नॉट। तो वो इसीलिए मेरा इनिशियल क्वेरी था पैनलिस्ट से कि वो जो है वो पीरियड कहाँ से अपने रिड्यूस करेंगे, एंड वी हैव कम टू अ कंक्लूजन।
इसमें मेरा ओपिनियन मैंने एक्सप्रेस नहीं किया, मेरा ओपिनियन तो एकदम डिफरेंट है। मेरा ओपिनियन ये है कि जो स्टे और ग्रांटेड आपका प्रोविजो पड़ी है उसमें क्या बोल रहा है, स्टे ग्रांटेड और इंजंक्शन ग्रांटेड, तो इसमें स्टे और इंजंक्शन की तो बात ही नहीं आ रही है, क्योंकि हाई कोर्ट ने नोटिस प्रेस कर दिए डायरेक्टली और सुप्रीम कोर्ट ने उसको वापस चेंज कर दिया।
सर कुछ पीरियड के लिए स्टे चला है, इनिशियली जो हम लोगों ने रीट फाइल करी थी उसमें कुछ स्टे,
सुप्रीम कोर्ट हैज टेकन केयर ऑफ दैट। सुप्रीम कोर्ट सेड ऑल राइट, लीव एवरीथिंग असाइड, फ्रॉम 4th of May 30 days आपको दे रहे हैं, उसके बाद में 2 weeks एसएससी को दे रहे हैं, so entire thing is covered therein। अब उसमें स्टे कोई बात नहीं है, only 30 days is given to the department to serve and 2 weeks are given to the SSC to reply, and that is mandatory now।
नहीं सुरना जी, वो आप बिल्कुल ठीक बोल रहे हैं, लेकिन उसमें थर्ड प्रोविजन में जो बात शुरू होती है ना, टाइम और एक्सटेंडेड टाइम, मतलब जो 15 दिन का टाइम अभी ये सुप्रीम कोर्ट ने दिया है, इसके लिए बोलते हैं ये भी टाइम मिल जाएगा उसको इशू करने का, इसमें मिल सकता है। मान लो किसी ने 30 जून को नोटिस इशू हुई थी 148 की, वो 148A हो गई, तो चूंकि 148A हो गई तो वो जो टाइम एक्सक्लूड होगा वो अभी से हो जाएगा इसकी।
Supreme Court has taken care of that. Supreme Court says now within 30 days you reply, the department will give the information material and you comply with that।
Then 2 weeks time have been given to reply, तो 2 week जो है ये एक्सटेंड हो सकता है, उनके कहने की, उनका व्यू है जो लिटिगेटिव व्यू हो सकता है।
Yes, हो सकता है, that is everything possible, but my view is that the Supreme Court has limited the time 30 days and 2 weeks, considering everything, क्योंकि वो जून अप्रैल से जून तक फिर उसका टाइम 148A ट्रीट करेंगे, उसको 148AB ट्रीट करेंगे, तो सारा टाइम एक्सपायर हो गया। So that to cover all those situations, now you take 30 days and 2 weeks veterans।
Correct।
This is what I say।
If I may explain once again, ये जो थर्ड प्रोवाइजो या फोर्थ प्रोवाइजो जो बात कर रहे हैं एक्सक्लूजन ऑफ डेट्स के बारे में, it refers to the period consumed between 148A within bracket B, जो नोटिस इशू होती है, शो कॉज नोटिस, कि why notice under 148 should not be issued, उसमें जो टाइम लिमिट दी हुई है, जो उसमें है, अगर उसमें एक तो हुआ कि एक तो कोर्ट का कोई स्टे आ गया उसके ऊपर में, तो फ्रॉम दैट डे टिल द डेट द स्टेट इज वो हो जाता है, उस समय तक की टाइम लिमिट एक्सटेंड हो जाएगी फॉर द पर्पज ऑफ इशू ऑफ नोटिस अंडर 148। लेट्स प्रिज्यूम कि अगर कोई 148 की नोटिस 31 मार्च 2023 को बाढ़ हो रही है, लास्ट डेट है 31 मार्च 2023 की, अब वो प्रोसीडिंग 148A की स्टार्ट हो गई मान लीजिए जून 2022 से, अब जून 2022 को जब वो 148AB की जब नोटिस दिया है, शो नोटिस जब करेगा, उसमें कोई स्टे आ गया मान लीजिए हाई कोर्ट का, तो वो जो पीरियड है, स्टे का पीरियड है, वो एक्सटेंड हो जाएगा 31 मार्च 23 जगह वो पीरियड बढ़ जाएगा। वैसे जो पीरियड जो उसने दिया है 7 डेज का टाइम टू रिप्लाई या एक्सटेंडेड पीरियड टू रिप्लाई, वो डेज और बढ़ जाएंगे। तो सपोज ये डिले जो है 15 दिन की है, तो 31 मार्च की जगह वो 15 अप्रैल तक वो नोटिस इशू कर सकता है। दिस इज व्हाट I have understood to mean by
टेब्रीवाल जी इज करेक्ट, क्योंकि अब लैंग्वेज देखिए तो 148 स्टे ऑफ 148 नोटिस की बात कर रहा है, नॉट 148A कैपिटल A, नॉट 148। यहाँ पर जो स्टे मिला था ये स्टे मिला था हमको सेक्शन 148 की नोट, क्योंकि 148A तो दिया ही नहीं उन्होंने।
सर अगर पूरा पढ़े हम, प्रोवाइडेड ऑल्सो that for the purposes of computing the period of limitation as per this section, the time or extended time allowed to the SSE as per so cause notice issued under 148 small b or the period during which the proceeding on 148A is stayed.
तो वो क्वेश्चन प्रेजेंट जो कंटेक्स्ट में जो नोटिसेस की हम बात कर रहे हैं, वहां तो ये प्रश्न उठ ही नहीं रहा है, क्योंकि वहां 148 दिया ही नहीं उन्होंने।
हाँ,
स्टे भी नहीं मिला है।
तो अगर उस समय अगर कोई एक्सटेंडेड पीरियड होगा तो उसमें काउंट होगा।
नहीं, अभी तो है ही नहीं ना सर, अभी तो 148 है ही नहीं। अभी जो आप जितनी आप
अभी ये नोटिसेस जो हो गई हैं, दे आर डीम्ड टू हैव बीन इशूड अंडर 148A, एंड नाउ द सुप्रीम कोर्ट हैज सेड दैट यू सप्लाई द इंफॉर्मेशन and the evidences and documents to the SSE, and SSE will reply within।
सर ये तो आज बोल रहा है ना सुप्रीम कोर्ट, बट हाई कोर्ट ने जो स्टे किया था वो तो 148 की नोटिस का स्टे किया था।
हाई कोर्ट
जब वो इशू किया था उस डेट में तो वो 148 बनी नहीं थी ना। ये तो आपको 4 मई 2022 से वो कन्वर्ट हुई है, आफ्टर सुप्रीम कोर्ट डिसीजन कम्स।
पहले जो
चलिए लेट अस
ओल्ड लॉ में हुई थी 148 की, वो तो खत्म हो गया ना, वो तो खत्म ही हो गया। तो उसका
मतलब कुल मिला के बात ये है कि सर सुप्रीम कोर्ट का डिसीजन विल थ्रो अप मोर लिटिगेशन।
हाँ, of course.
So we have all the reasons to smile.
And in most of the cases, I'll say litigation will be in favor of the SSE, because the judgment of Supreme Court is SSE oriented judgment.
भैया सुशील भी आपका म्यूट करिए, अनम्यूट करिए भी सुशील भैया।
And Supreme Court CBDT has compounded this problem again.
सुप्रीम कोर्ट ने कहा कि 148A जो है इज ट्रांसफॉर्मेशन ऑफ द ओल्ड लॉ। जो जीके एंड डैश में कहा गया था उसको इन्होंने 148A में स्टैट्यूट में ले आया। पहले रीजन्स के लिए वो हमको मांगना पड़ता था, अब ये बोलते आपको देना ही है, पहले ही देना है इंफॉर्मेशन। उसको ऑब्जेक्शन आपको करना है, वो आपको करना है।
फिर सुप्रीम कोर्ट ने
ऑर्डर बना करके, तो ये तो एसएससी फेवरेबल है भाई।
कई क्वेरीज जो है ना या तो रिडंडेंट है या समझ में ही नहीं आ रहा है। एक पीयूष अग्रवाल जी ने कुछ कहा है, या तो आप अनम्यूट करके पूछिए। ये इतना लंबा क्वेश्चन
मुझे वो अपने बोले क्या चाहते हैं
नितेश जी, इनको पीयूष अग्रवाल जी को अनम्यूट करिए। उनको कुछ इनका एक लंबा सा क्वेश्चन है जो मेरे समझ में नहीं आया।
पीयूष जी आप शो ऑफ हैंड्स यदि दिखा पाए तो हम लोग ये कर सकें आपको। पीयूष अग्रवाल।
Yes, sir.
हाँ प्लीज
सर, माय क्वेश्चन इज कि दैट इज सर सुप्रीम कोर्ट ने अपने डिसीजन में असेसमेंट दिया 13, 14, 14, 15, 15, 16 के लिए कुछ नहीं कहा। जो सीबीडीटी की इंस्ट्रक्शन आई उन्होंने 50 लाख, मोर देन 50 लाख एंड लेस देन 50 लाख, इसका एक डिस्प्यूट क्रिएट किया। लेस देन और मोर देन 50 लाख का डिस्प्यूट इसमें से क्रिएट किया कि 15, 16 की टाइम बारिंग 31 मार्च 2022 थी। ओल्ड एक्ट में हम इस लिमिट से ज्यादा नहीं जा सकते थे, पर न्यू एक्ट में 10 ईयर्स के लिए जा सकते थे। पर जो 149 का प्रोविजो है, उस प्रोविजो 1 में उन्होंने कहा कि 1 अप्रैल 2021 फाइनेंस एक्ट से पहले की जो भी ईयर्स हैं उसमें बियॉन्ड टाइम नहीं जा सकते, जो कि 6 साल था। और हमारा आर्टिकल 21 कॉन्स्टिट्यूशन भी ये कह सकता है कि जिस टाइम जो ऑफेंस किया है उस टाइम जो एप्लीकेबल लॉ था उससे आगे हम नहीं जा सकते। इसी चीज को मीट आउट करने के लिए सीबीडीटी ने इंस्ट्रक्शन जो दी वो असेसमेंट ईयर 15-16 तक कवर किया, क्योंकि वो 31 मार्च 22 तक कवर हुआ। बाकी आप पहले जो है उसके बारे में बेहतर बता सकते हैं।
नहीं, सीबीडीटी ने जो भी टाइमलाइन दी है, वो जो टाइमलाइन दी है वो थ्योरी ऑफ रिलेट बैक के हिसाब से दी है। जो सुप्रीम कोर्ट के हिसाब से हम लोग इंटरप्रेट कर रहे हैं असेसमेंट ईयर वाइज, और आप इनका सीबीडीटी के हिसाब से ईयर वाइज आप देखते हैं, टोटली डिफरेंट है। ये कोइंसिडेंटल है कि ये 3 साल का बिलो 50 लाख हमारे बीच में उसमें कॉमन हो रहा है।
नहीं,
अदरवाइज सीबीडीटी तो ये सोच रहा है कि 13, 14, 14, 15 भी वैलिड है, क्योंकि दैट ट्रेवल बैक टू द डेट वेयर टू बी इशूड, जो कि इलीगल है।
ठीक है, पर अगर हम सीबीडीटी की इंटेंशन समझें कि उन्होंने असेसमेंट ईयर 15-16 तक को ही 50 लाख से तक के लिए क्यों कवर किया, अप टू 50 मोर देन 50 लाख, तो उनकी इंटेंशन यही है क्योंकि ये वाला जो नोटिस था असेसमेंट ईयर 15-16 का ओल्ड एक्ट में 6 ईयर तक 31 मार्च 2022 तक जा सकता था, 16 + 6, बट इन न्यू एक्ट दे आर कवरिंग दिस मोर देन 50 lakhs फॉर द 10 years, but this is not applicable due to the first provision or the 149.
मेरा व्यू ये है कि सीबीडीटी का इंटेंशन बिल्कुल क्लियर है। सीबीडीटी का इंटेंशन ये क्लियर है कि मेरे को कुछ डिसाइड नहीं करना है, लेट द कोर्ट डिसाइड, क्योंकि वो इतने भी नेव नहीं है कि उनको ये सुप्रीम कोर्ट जजमेंट पढ़ना नहीं आता है।
नहीं सर, पढ़ने का नहीं है,
प्लेन जजमेंट बिल्कुल प्लेन एंड क्लियर है, और उनको समझ में नहीं आ रहा है। समझ में आते हुए भी उन्होंने पिक एंड चूज अपनाया है। पिक एंड चूज किया, एक पैराग्राफ ले लिया, एक पैराग्राफ छोड़ दिया, कहीं कुछ ऐड किया नहीं किया, टोटली परवर्स स्ट्रक्चर में कह सकता हूँ इसको।
ठीक है सर,
पर वी कैन टेक नेक्स्ट क्वेश्चन। हाँ पीयूष जी, हो गया, नेक्स्ट क्वेश्चन प्लीज। हरिराम जी एंड गिरधारी शर्मा जी, आई विल रिक्वेस्ट यू टू काइंडली आस्क क्वेश्चन।
ओके सर। ये क्वेश्चन इसमें जो आए हुए पार्टिसिपेंट्स के, वो मैं क्या करके पढ़ लेता हूँ। इन बैंक अकाउंट देयर आर क्रेडिट ऑफ सेल्स विच हैज बीन विथड्रॉन टू मेकिंग पेमेंट टू परचेज, देयर इज नो इनकम रिप्रेजेंट एसेट्स। तो ये इस केस में खुल सकता है क्या? हेलो,
I think any of the panelists can reply, please.
Yeah, question again, please. Question में
बोल देते सर। अगर बैंक में रुपया नहीं है, बैंक में रुपया जमा और खर्चा हो गया, तो वो उसका क्या खुल सकता है क्या, ये पूछ रहे हैं।
ये खर्चा होने का रुपया जमा हुआ से कोई लिंक नहीं है। अगर आपका जमा हुआ है, सोर्स हुआ है, आपका मेरिट पे आपका टेस्ट डिसाइड होगा, अपार्ट फ्रॉम द लीगल पॉइंट। वो पूरा फैक्ट देखना पड़ेगा, क्या सोर्स है नहीं है, तब ये डिसाइड होगा।
हरिराम जी।
हाँ, पर मेरे ख्याल से वो इम्पोर्टेंट होगा उसके पर्पस के लिए। वो जो एसेट वर्ड है ना,
एसेट्स का रिप्रेजेंट नहीं है, वही बोलना चाह रहा है।
केस है, कौन सी साल का केस है, सो मेनी फैक्ट्स हैज टू बी सीन। 18-19 है या 15-16 है,
वो भी देखना होगा,
वो भी देखना होगा।
so many things has to be seen.
अच्छा, एक क्वेश्चन है सर, 16-17 का खुल सकता है क्या 148 में, अगर 50 लाख से ऊपर है तो?
50 लाख से ऊपर क्या है
इनकम?
खुल सकता है, 16-17 खुल सकता है, और बल्कि सीबीडीटी ने तो 3 साल से कम का माना है 16-17 को, 50 साल से कम का भी खुल सकता है। उसमें लिखा है, गलत लिखा है उन्होंने। वो उनके ही शायद टाइमलाइन से भी गलत है वो।
पर एक चीज सर, ये भी डिपेंड करता है कि क्या टाइप का है। यदि वो एसेट है, यदि वो एंट्री इन द बुक्स है, लोन है, लोन ट्रांजैक्शन है, तब थोड़ी खुल सकता है।
नहीं, उसमें तो एसेट अनडिस्क्लोज्ड है ना, एसेट तो डिस्क्लोज्ड है।
हाँ, तो वो तो सर्च में मिलते हैं सर, वो नॉर्मली तो
शर्मा जी का जो क्वेरी है कि कैश में, बैंक में कैश डिपॉजिट हुआ है from time to time, which is in aggregate is more than 50 lakhs rupees, if I may say so. But that money has been withdrawn from time to time for purchase of goods. That means that the HSE is carrying on the some retail business, and purchase are made and sales are made in cash. There are so many judgments where the courts have said simply because cash has been deposited in the bank cannot be an inference to be drawn that income has escaped assessment. तो जब नोटिस अगर आती है, इसकी इंफॉर्मेशन बेस्ड नोटिस अगर आती है, तो आप यू हैव टू रिप्लाई अंडर जो 148 AB सॉरी स्मॉल b में जो शो हो जाएगी, उसको आप रिप्लाई कीजिए, उसमें पूरा डिटेल्स दीजिए उसको, भाई दिस इज आई एम यूजिंग इट फॉर रिटेल ट्रेड एंड देयरफॉर देयर इज नो।
सिबडेवाल जी उन्होंने ये नहीं कहा बैंक अकाउंट डिस्क्लोज है, डिस्क्लोज है।
नहीं, वो बता रहे हैं कि बैंक अकाउंट में कैश जमा किया था,
बैंक में रुपया जमा
अनडिस्क्लोज हो, इवन अगर अनडिस्क्लोज है तो भी अगर परचेज आर देयर.
सर अनडिस्क्लोज्ड, आई जॉइन इश्यू ऑन दिस. अनडिस्क्लोज्ड बैंक अकाउंट है तो एसेट के डेफिनेशन में आ जाएगा इन माय ओपिनियन.
एसेट की डिफाइन है बैंक बैलेंस.
किसी भी टाइम में 50 लाख से पीक क्रेडिट है ही नहीं बेसिक, तो हाउ इट कैन बी एन एसेट? Asset could be only the peak credit balance in the bank.
सर बैंक अकाउंट में यदि अब पीक क्रेडिट ये सब डिबेटेबल पॉइंट हो गया.
इनका जवाब नहीं दे दिया जा सकता भैया, पूरी फैक्ट्स के बिना. ये यहाँ का नहीं है.
हाँ शर्मा जी आगे और कोई क्वेश्चन
अच्छा,
है?
और क्वेश्चन पढ़ा, और क्वेश्चन है, कैन जेओ सीक एक्सटेंशन इफ फेल टू
क्वेश्चन का फिल्टर करते रहिए क्योंकि हर क्वेश्चन जवाब देने लायक नहीं है.
नहीं, एक क्वेश्चन है कि भाई अगर एसएससी का ऑफिसर एक्सटेंशन मांग सकता है क्या, कि अगर वो 30 दिन में नोटिस नहीं देता है तो?
वो तो हो गया ना, डिस्कशन हो गया.
तो हो गया, नहीं दे सकता.
Hariram ji, if you want
notice issued 148 for 1718 on 20 April 21 for cash deposit for less than 50 lakhs. Will it be good after Supreme Court decision? Notice issued 148 for 1718 cash deposit less than 50 lakhs.
Gone. Below 50 lakhs gone.
Gone. 15-16 भी वैसे gone हो गया.
लेकिन सीबीडीटी के हिसाब से नहीं गया है. सीबीडीटी लड़ना पड़ेगा.
Whether in view of Supreme Court order, notice shall be issued afresh giving 15 days, where order 148A has been issued giving 30 days time.
कम पीरियड में आपको सर्व कर दिया तो क्या गलत है? मैक्सिमम लिमिट है 30 दिन का.
ठीक ही है.
कोई एओ एफिशिएंट हो गया तो उसका थोड़ी आपको एडवांटेज मिलेगा. ये थोड़ी है कि 30वें दिन ही आपको इंफॉर्मेशन मिलना चाहिए.
एक क्वेश्चन है, कैन द पीरियड फ्रॉम 1/4/21 till date of Supreme Court judgment be excluded for the purpose of limitation in view of third and fourth proviso amended to section 149(1).
वो भी डिस्कशन हो गया, ये इररिलेवेंट है.
हाँ.
One question is, can panel please discuss on defects in instruction 1 in their individual views?
वो भी डिस्कस हो, तो इतनी देर से यही डिस्कशन हो रहा है सर.
आर्टिकल का भी डिस्कस हो गया. हाउ फार सुप्रीम कोर्ट इज करेक्ट इन अप्लाइंग आर्टिकल 142, वो भी डिस्कस हो गया.
वो एकेडमिक चीज है, उसमें अपने वो क्या लेना था.
बहुत बड़ी चर्चा हो जाएगी.
If reason for reopening has already been provided through 143(2) notice previously, whether assessee shall furnish reply based on that 143(2) issued earlier or fresh notice will be issued.
नहीं, आपका वो 3 महीने में नोटिस थी तो फ्रेश नोटिस मान ली जाएगी ना. तो आपका मटेरियल आएगा, उसका कार्रवाई चलेगी, जो हो गई सो.
सुशील जी, 143(2) थोड़ी फ्रेश दरकार है.
नहीं, मैं वो नहीं बोल रहा हूँ. मैं बोल रहा हूँ कि 148A हो गई ना नोटिस, अगर 3 महीने में.
तो अब तो नया चलेगा ना.
नया चलेगा ना, वो सारा चीज इंस्ट्रक्चर्स हो गया.
अच्छा, वो 148 के बाद नया 148 के बाद फिर 143(2) देना होगा.
करेक्ट.
सर एक इशू मैं रेज करता हूँ, इम्पोर्टेंट इशू है. जितनी भी नोटिसेस इशू हुई,
दिस विल बी द लास्ट क्वेश्चन सर.
148 की जो
सर आपका ये लास्ट क्वेश्चन रहेगा.
सर एक दो क्वेश्चन और ले लेंगे हम लोग सर लास्ट में.
सर 148 की जो नोटिसेस इशू हुई थी, जिसको कि उन्होंने क्वेश्चन कर दिया, प्रैक्टिकली कन्वर्ट कर दिया उसको 148A में. Now those 148 notices were issued were on region based notices. Region based escapement of income. Whereas now 148A में है information based. अब क्या है कि जो मटेरियल इंफॉर्मेशन देंगे वो तो वही देंगे जो पहले इन्होंने रिकॉर्ड कर रखा है. Those were regions based. Could it, I mean, how to correlate these notices which have been considered as 148A, which should be issue based, information based.
नहीं 148 चूंकि
Information has been defined now. The flag or audit objection.
148 notice was issued on the basis of reason to believe.
Right.
Okay. Now that has become 148A information base. तो 148A के दायरे में वो आता है, दो इंफॉर्मेशन उस समय में थी, रिस्क
रेड फ्लैग
एंड रेड फ्लैग हो तभी हो सकती है। अगर उसमें आएगा तो आपका लीगली स्टैंड करेगा, रीजन टू बिलीव भी भेज देता है, या कोई सी इंफॉर्मेशन जो उस फ्लैग में नहीं आती है तो वो इनवैलिड हो जाएगा।
लेकिन सर एक चीज इंटरेस्टिंग ये चीज समझ में आ रहा है कि रेड फ्लैगिंग के लिए जो पैरामीटर्स थे वो शायद अभी तक डिफाइन नहीं हुए हैं।
नहीं, तो उनकी इंटरनल है सारी मामले, वो पब्लिक नहीं है।
नहीं, पर ये जब हम चैलेंज
वो डिफाइन तो हो गए हैं, लेकिन वो 10/12/2010 में उनका नोटिफिकेशन निकला 135A का, लेकिन वो तो बाद में डिफाइन हुए हैं ना, वहां तक तो डिफाइन हुए नहीं, 1/4 से 30/6 तक डिफाइन, इसलिए वो फ्लैग में आएंगे ही नहीं।
तो जब वो लोग
लॉ तो अपने को फ्लैग वाला ही लगेगा ना।
हाँ, वही लगेगा।
नो फ्लैग वाला
अब वो रीजन टू बिलीव नहीं रहा,
आइदर फाइनल ऑडिट ऑब्जेक्शन और द फ्लैग इंफॉर्मेशन।
यस,
नहीं तो वो तो डिपार्टमेंट को फिर जस्टिफाई करना होगा ना कि ये रेड फ्लैग्ड इंफॉर्मेशन था।
ये डिफेंस रहेगा अपना, डिफेंस रहेगा ये अपना।
That will come in information and the material.
या अगर आप उसको चैलेंज कर सकते हैं, अपने सूट नहीं कर रहा है तो करेंगे, उसको चैलेंज करेंगे
अपने। वी शुड देन आस्क फॉर कि आपका क्या रेड फ्लैग्ड इंफॉर्मेशन था, प्लस एविडेंस दीजिए हमको। एविडेंस भी तो मांग सकते हैं ना भाई, जो इंफॉर्मेशन है वो क्या, आपको कोर्ट ने तो शायद दोनों ही वर्ड यूज किया है कि आपको इंफॉर्मेशन और डॉक्यूमेंट्स देना होगा।
मटेरियल एंड इंफॉर्मेशन
बोथ देना होगा। तो और डिपार्टमेंट बंद गया इसमें, मटेरियल तो कभी लाते ही नहीं थे ये लोग ऑन रिकॉर्ड।
उनके पास है ही नहीं, लाएंगे कहां से?
पहले तो आप चैलेंज करते थे रीजंस टू बिलीव, अब तो आप मटेरियल वाला भी चैलेंज करोगे भाई सुप्रीम कोर्ट बोल रहा है मटेरियल दो, आपने मटेरियल दिया कहाँ? और
And not only in these cases, for all times to come, all times to come.
If I may give an example, I have seen a notice of 148A, जहाँ पर उन्होंने इंफॉर्मेशन जो कलेक्ट किया लिखा है कि you have purchased a property of 35 lakhs. Then they say कि there is an information of 48 lakhs. Now वो 48 lakhs का जो फिगर है वो उन्होंने उन दोनों को जोड़ करके 50 lakhs से ऊपर बढ़ा दिया। But ये 48 lakhs का फिगर जो है स्टैम्प डिवैल्यूएशन है of the same property. So unless until they give me the materials and evidence कि भाई 48 lakhs क्या है, केवल informations तो होगा नहीं। And this is what the materials or evidence required has to be given to me.
शर्मा जी और है कुछ, एक दो क्वेश्चन है।
एक क्वेश्चन और है कि 148 में नोटिस आया है, उसमें लिखा है कि आपने कैश लोन 10 करोड़ रुपया का लिया है और इसका इनकम स्टेटमेंट हो गया है। ब्रोकर ने कहा है कि आपको रुपया दिया था, आपने लिया है, तो इसमें वो क्या करेगा? तो बुक्स में कोई एंट्री भी नहीं है, कैश लोन लिया हुआ है तो, और वो इनकम कैसे होगी जब कैश लोन ही लिया है?
कैसे नहीं इनकम होगी?
कैश लोन बोल रहा है ना, कोई बुक एंट्री तो बोल नहीं रहा है, अब बुक में एंट्री भी नहीं है।
एविडेंस है वो, लेकिन इसमें ये बात है कि इसमें आपका कोई भी जो लोन है वो दिस इज नॉट रिप्रेजेंटेड बाय एनी एसेट, because nothing is found that it is represented by any asset. It is information only.
Sir, if it is an accepted fact that I have received cash loan cannot be income. Number one. Number two, unless it is found recorded in the books of account, because section 68 says where any entry is found recorded in the books of account, which I cannot explain, then only 68 will apply. Otherwise 68 will not apply.
Sir, उसमें खाली books of account नहीं है, documents and evidences भी है।
तो 269 एसेट्स में भी कैसे होगा?
मेरे ख्याल से ये जो क्वेश्चन कर रहे हैं वो रिलेटिंग टू सम मनी ब्रोकर के यहाँ सर्च वर्च हुआ तो उसने कोई स्टेटमेंट दिया, उसके बेसिस पे बहुत लोगों का रीओपन हुआ, उस टाइप का केस।
हाँ, उस टाइप का ही है।
हाँ, तो वो कोई रिकॉर्ड तो कुछ है, कोई डायरी में कुछ वो खाली मेयर स्टेटमेंट ही है, और रिकॉर्ड भी होगा तो उसकी डायरी में भी यदि कोई नाम मिल गया तो हाउ कैन आई बी indicted on that basis. हमारे रिकॉर्ड में तो
जिसने दिया है उसके केस में 68-69 में एडिशन करो. अगर जिसको मिला है कैश लोन, that cannot be treated as an income scaling assessment.
और वो 269 SS और T का भी नोटिस दिया, वो भी नहीं वैलिड होगा क्योंकि बुक्स में एंट्री नहीं है लोन की.
269 ST वो अलग इशू हो गया,
अलग इशू हो गया.
For that reason, I mean, for that purpose, 148 cannot be issued.
Oh, correct.
But then SSC should deny कि ये ट्रांजेक्शन मेरा है ही नहीं, तो SS वगैरह से बचने के लिए बेटर है कि डिनाई करे, क्रॉस एग्जामिनेशन मांगे.
Correct. Thank you,
Last
sir.
question, sir. Any more last question?
For assessment in 18-19 notice issued on 25 March 22 to report by 28 March 22. SSC objected a 7 days time, not given. A issued notice under 148A dated 30 March and informed to ignore earlier notice and sent on wrong email. वो तो पुराना बात हो गया, मतलब नहीं है अभी. Is this a time barred?
सर ये पैनलिस्ट से मैं ये पूछना चाह रहा हूँ कि 148 में कोई इरेगुलरिटी है, उसके वजह से क्या असेसमेंट क्वैश हो सकता है? इरेगुलरिटी मतलब उसने जो स्टैट्यूटरी टाइम लिमिट दिया हुआ है वहां उसको स्ट्रिक्टली फॉलो नहीं किया.
सुभाष जी, अब ये बन गया मैंडेटरी रिक्वायरमेंट ऑफ लॉ, अभी इरेगुलरिटी नहीं है. इफ एनी मैंडेट गिवन बाय सुप्रीम कोर्ट इज नॉट फॉलोड, इट बिकम्स अ ज्यूरिसडिक्शन.
मैं सुप्रीम कोर्ट की बात नहीं बोल रहा हूँ सर. मैं
ऐसे सुभाष जी की पहले 148 में 30 डेज का टाइम लिखा रहता था, अभी आज की तरह नहीं है. पहले 148 में 30 डेज का टाइम था. सम केसेस the ITO did not allow 30 days and all those assessments were quashed by the courts. There are number of judgments on that. Thereafter they removed this 30 days time limit. अब ये कर दिया, this such time has may be allowed by the assessment officer.
पर इसमें सर कॉन्ट्ररी जजमेंट भी होंगे, क्योंकि जहाँ डिनायल ऑफ नेचुरल जस्टिस है वहां कोर्ट्स का नॉर्मली व्यू ये रहता है कि इसको रिस्टोर बैक करने का.
इसमें स्टेचुटरी टाइम में रिस्टोर बैक क्या करेगा? ये बोलेगा कि नहीं 30 डेज टाइम तो
आपका ग्रीवांस तो यही है ना कि हमको 30 दिन मिलना चाहिए था, हमको 5 ही दिन दिया या 7 दिन.
मेरा
डिनायल ऑफ नेचुरल जस्टिस है.
कोर्ट ने 5 साल बाद में जजमेंट दिया तो 148 5 साल बाद में मतलब 15 साल बाद में शुरू कर देगा. ऐसा किसी कोई भी केस में रिस्टोर नहीं किया है. टाइम इज नॉट गिवन, द असेसमेंट इज द नोटिस इज प्लेस्ड. अब आपको फ्रेश नोटिस का टाइम है, जैसा कि अभी इसमें दिल्ली हाई कोर्ट ने बोला है आपका जो 148 ये वाले चक्कर में कि अंडर द एग्जिस्टिंग प्रोविजंस ऑफ लॉ यू कैन इशू फ्रेश नोटिस, यू कैन इशू. सो सिमिलर थिंग्स वर देयर.
वो तो उल्टा कर ही दिया ना सुप्रीम कोर्ट ने.
उल्टा कर दिया सुप्रीम कोर्ट ने. ये बोलते हैं ना कि तो हाई कोर्ट ने ठीक बोला है, इसको 148 ट्रीट कर लो बस.
नहीं बोले. अच्छा, ये इस पर आपका क्या कहना सर? बोनाफाइड एरर ऑफ द ऑफिसर्स, तो हम लोगों के बोनाफाइड एरर में भी हम लोगों को लीवे मिलेगा क्या?
नहीं, वो उन्होंने क्या है, जस्ट टू गिव द लीवे they have made out this way कि ये बोनाफाइड एरर है, because you have agreed, all the lawyers have agreed to that proposal. सुप्रीम कोर्ट ने अपने माथे पर लेके कोई जजमेंट नहीं दिया है. they have proposed कि भैया ऐसा पास कर दें, आपने कहा जी कर दो, हम राजी हैं. तो दोनों को राजी है, सुप्रीम कोर्ट क्या तकलीफ है?
सुप्रीम कोर्ट ने आर्बिट्रेशन कर दिया.
आर्बिट्रेशन कर दिया. आप बोलते नहीं साहब आपको मंजूर नहीं है, दिस ऑर्डर शुड बी, दिस नोटिस शुड बी डिक्लेयर्ड नल एंड वॉइड. तब सुप्रीम कोर्ट करती, तब देखा जाता. सुप्रीम कोर्ट ने वो नहीं किया है. They have agreed whatever you propose.
नहीं, ये क्या जजमेंट इन पर्सोनेम है या इन रेम है?
अब इतने चक्कर में पड़ जाओ इसको. अब जजमेंट है उसकी, सोचोगे जजमेंट है ये.
चलिए सर, अब कंक्लूड करते हैं. आप सभी को बहुत बहुत धन्यवाद. At the end of the day, we are much wiser now, and we are better prepared to handle the ensuing situation coming out of the Supreme Court decision. So I think till at this hour of night also we have around 200 persons as audience.
And hundreds are watching in YouTube channel also, sir.
हाँ, YouTube में भी देख रहे हैं. पूरा
भारत में तो 500 से ऊपर थे सर. अच्छी अटेंडेंस हो गई आज।
हाँ, तो ऑर्गेनाइजर्स को भी बहुत बहुत बधाई फॉर द सक्सेस ऑफ द टुडेज पैनल डिस्कशन एज वेल एज स्टडी सर्कल
ये तो आप लोगों के
सर आप लोगों को
आशीर्वाद
बहुत बहुत
से ही,
धन्यवाद, आप
लोग
लोगों
थे
के आने
इसीलिए
से
हुआ।
हुआ सब।
हाँ। With this, may I now request Umang Chapadia, the Joint Secretary, Views Exchange, to kindly offer her vote of thanks to the learned speakers, please, panelists and moderators.
I would like to thank our moderator for today's session, Subhash sir, who has taken the session in such a fantastic manner on this topic of on this hot topic, which is on section 148, analysis of CBDT circular on 148. With more than 250 people who are attending today's, that people were very eager to listen to the panelists who were there, and all the prominent panelists such as Sushil sir, Anand sir, Surana sir, who were there and who were discussing on the topic of 148. We would like to thank each and everyone, all the sir who has, all the panelists today who took out their valuable time and shared their opinions on shared their views on 148 and 148A issue. So with that, I would not like to take more time, as we are already at this late hour of today's evening. With that, once again, thank you to all the attendees, the panelists, and to the moderator, and also to Views Exchange for organizing this session. Thank you so much, everyone.
Thank you. Good night to everybody. Thank you, sir.